CBI matters. So you can take the files and then prepare. At least the first 9 items. The files you got in the morning today. We'll fight for workout ways. Don't worry. Yes.
My lord. My lord, the charge was under section 326. Affair was lost under 320. Then it was added. They added section 302. Charge was submitted under section 326. Then, my lord, court dropped the charge 326. And ultimately, punishment was under 323. From affair, it appears that my lord, PW1 is the eyewitness, my lord. PW1, my lord, while making allegation in the affair, did not name PW5. PW5 of his own projected himself to be the eyewitness. Lordship has rightly pointed out other days, 1, 4, and 5. 3 witnesses are relevant for the purpose of deciding. And on the other hand, my lord, whether the evidence of 1, 4, and 5 can be said to have been supported by, my lord, PW8 and PW9. PW8 is the doctor, and what is the opinion of the doctor? Doctor is very specific in saying that the cause of injury is not the, my lord, any, my lord, spade blow. That cause of injury is the, my lord, heart disease. And inquest report.
That is why 302 was dropped.
Exactly. Therefore, the only question, my lord.
But the grievous hurt is established.
Grievous hurt was not established because charge was not ultimately adjudicated under section 326. It was adjudicated under section 323.
Convicted under 323.
Right. Therefore, my lord.
Okay, you can have your evidences if you want.
My lord. I don't know, my lord, how much, to what extent I have prepared the case. But first of all, Lordship, kindly, page 9 in my petition, my lord. Because my lord, other days why I apprise your Lordship, my lord, we don't have the copy of the evidence. And whatever evidence we have, my lord.
Mr. Purkhaista, if you are finding it difficult to argue, we can adjourn this matter
My lord.
With a cost of 25,000.
No, I'm not saying adjournment.
No, if you have not prepared to the full extent.
I am not saying that.
Okay.
I'm saying that, my lord, since certificate copies.
No, there were 2 utterances that you don't know how much you can do. I don't want to put you in trouble.
No,
but the wastage of time, I'll have to be compensated.
Because I don't want to be put myself into trouble.
Yes.
Therefore, my lord, Lordship, kindly come to page 9
of
my petition.
Okay.
I have quoted, my lord, whatever statement was made by PW5. May I read, my lord? PW5.
We have the original statement with PW5. You can refer to that.
Yes. My lord, record may be allowed.
I had given you, Mr. Majumdar, the liberty last time that he can make his notes. Yes, you can have this records if you want.
Yes. Also, can you come to page 9? Statement made by PW1 under section 161 in course of investigation. Affair was lost on 6/6/2010. I'm reading, my lord. I am residing in the house of my Dharma Pita.
Where are you reading?
Page 9.
Of the appeal memo. Page 9 is the part of the judgment.
Page 9.
Oh, sorry.
Part of the report.
Sorry. Yes.
161 statement.
Now, what is the value of this 161 statement when we have a deposition on record?
161 statement. Maybe
have you comforted her with that one? Just show me from the the evidence that you had comforted her. Thereafter, we'll go to 161.
No, 161 may be used to contradict or corroborate the.
You have to do that in the trial, Mr. Purkhaista. Have you done that?
Yes, we have done that.
Just show me that first.
Then Lordship, can they come to straightway to judgment? It will be better. What extent court has considered the evidence of PW5?
Para 8.
Right. Let me now deal at page 36. Let me now deal with the evidence of these three witnesses. One by PW1 deposed that on the date of occurrence around 6:30 a.m., her husband went to the paddy field along with Monindo Kalindi, PW5. And Monindo started plowing the field and he asked her husband to remove the block water from the field, and her husband accordingly removed. But before my lord, referring to this particular paragraph 8, I would like to point out, my lord, whether Monindo was said to be the eyewitness in the affair. If Monindo is not projected to be, my lord, eyewitness in the affair, then Monindo's statement cannot be taken into consideration.
Okay. First submission, Mr. PW5 cannot be
said to
considered.
Witness because he was not cited as eyewitness in the affair.
Where is the law to this extent?
Yes, my lord. Because prosecution law is to, my lord, put into motion on the basis of the affair. Where if affair says that nobody was present except PW1, who, my lord, witnessed the incident while standing in the near the pond. Nobody was physically present at the time of occurrence, my lord. Subsequently, Monindo was incorporated.
Upload koi dia. Matile pindi kumai guse hi bajune.
And husband to remove the blocked water from the field, and her husband, and accordingly remove the earth to facilitate the flow of the water. And the water entered in the field of the accused. Then accused rushed to the field with a spade and asked her husband to stop the water. And thereafter he assaulted the husband with a backside of the spade. But if that part of the statement is acceptable, my lord, backside of this spade, there was a blow and he sustained injury on the neck of the backside of the neck. Kindly refer to, my lord, I may refer to evidence of PW8.
No,
There is no external and internal.
Your submission is he got a blow from the backside of the spade where?
On the neck.
Where is that?
Back of the neck.
Where is that?
Yes, I'm coming. Backside of the spade, as a result, her husband fell down.
That part is not there.
And further evidence is that at the time, at that time, she was at the bank of the tank, claiming rice and witnessed the incident. On seeing the same, she rushed to the place of occurrence and found the husband lying on the ground. According to her son Raju, PW3, also followed. Her neighboring people also assembled there, and they carried her husband to the house, and wherefrom he was taken to hospital, wherefrom he was shifted to Shilchar Medical College. She also accompanied her husband to Shilchar. After 3-4 days of the incident, her husband expired on the next Sunday around 8 p.m. at Shilchar Medical College. In her evidence, she has explained the delay in filing so and so and so. Now, my lord, lordship, kindly, my lord, read, my lord, PW1 evidence. From I have some eyesight problem. He will, my lord, read.
Kindly, oh, we will read it for you. Don't worry. You be there. Give me that book. A record to go to sir. You have the record.
Yes.
What do you want to highlight? You just tell me. We'll not trouble you with that.
It was sustained on the backside of the neck.
Injury sustained not on the head but on the backside.
On the backside, on the neck.
The neck.
And to that extent, I will add one more thing. That inquest report, medical report, post-mortem report does not indicate anything, do not indicate anything regarding injuries sustained on the backside of the neck or head. No external and internal injury.
Let us get over with this first part, PW1.
PW1. 9. 151. Right.
The crosses,
Yes.
I came to know that the accused assaulted my husband on his forehead. True. Neck, chest and shoulder.
Yes.
So there is material,
Yes.
but there is one more material here that she does not know
How many blows?
were given.
My lord.
That is in the cross somewhere.
Yes. Therefore, if there are multiple injuries on various parts of the body, then there must have been continuous.
Okay,
blows.
next, what is your submission?
Then, my lord, PW 5.
PW5. Yes. Monindra Kailandi.
Court projected court accepting him to be eyewitness. So therefore, my lord, in view of the version or my lord, allegation made in the affair, whether PW5 can be accepted to be an eyewitness.
We have already taken that.
I have already taken. So once PW5 is not eyewitness, and subsequently he was incorporated or inserted or projected as eyewitness, therefore his evidence is of no significance.
Okay.
And his evidence was also not supported by one medical report, postmortem report, as well as the inquest report. Then Lordship may kindly, PW3 was also projected to be eyewitness. She also made the same statement as that of PW1.
She was in the pond.
On the pond. But there is no one in reference, either by PW1 or PW5.
Of her presence.
Her presence. Therefore, PW3 will also go. And she made them identical common statement, as usual statement. I was. And court did not consider, my lord, other witness. Now, Lordship kindly come to PW4. PW4 made different statement in under 161 and, my lord, during the course of trial. He also projected herself to be the, my lord, eyewitness.
But you had not comforted her with that during cross. Nothing is there.
Regarding whom? PW4?
4.
Just a minute, madam. Cross-examination. I was the fact. I was the first person who could be able to, my lord, the said incident. I found one injury in the backside of the neck. Whether he is a trustworthy or credible witness.
You show me.
Oh, my lord.
Here, how can I say? You have to argue.
I'm posing myself. Now, my lord.
I want the answer.
Yes. No. I have to give the answer.
And that's it.
My lord, therefore, the test to be applied before considering the evidence of a witness, court is to take into consideration whether he or she is credible or trustworthy. These are the two basic principles, if I'm not wrong. Therefore, my lord, if PW4, by projecting herself to be the eyewitness and made a statement, then I am the only person who is able to give the correct, my lord, fact. What actually, my lord, occurred. He said there was an injury in the backside of the neck. And if she is a witness, my lord, she is very specific that there was injury I found on the backside. Now, whether that part of the statement can be, my lord, controverted or confronted or supported by medical evidence or inquest report. Inquest report is a report, my lord, which was prepared at the very first instance.
Okay.
Therefore, my if does not reflect if it is not reflected
Mm.
in either of the report,
Mm.
then that part of the statement made by the PW4
Where did you comfort her with that inquest report?
is not necessary, my lord. Because if record shows a statement is not in conformity or in tune with the-
Where is your? You will have to bring that. A suggestion at least. For the court to come into that, look into that, there
Yes.
has to be a dispute raised.
So the whole, my lord, approach of the court is to find out the veracity of the prosecution case.
Okay. Anything more, Mr. Professor?
Therefore, my lord, if PW1,
Your case is that the evidences of the eyewitnesses,
yes,
even if it is taken as eyewitness,
my lord,
it's not corroborated by the medical evidence.
my lord. And medical evidence as well as PW1, PW9.
Now, you
Number
were
nine.
examined under 235. You were examined under 235 for the purpose of the quantum of the punishment.
Now, my lord, that
Have you seen the statement you made therein?
(235) at page 24, at para 24, page
Okay.
45. Heard the accused from the point of proposed sentence
Mm,
under section
Mm.
235(2)
mm,
CRPC.
mm,
The accused pleaded for leniency,
mm,
stating that at the time of incident he was aged about 20 years
mm.
old, and he got
Enraged.
enraged when the when the paternal uncle released the blocked water towards the field and could not assist himself. Now he is dependent
Mm.
for this mistake. My lord, if that part of the statement, if your lordship says that it is an admission,
Not an admission, it is only a plea. It's only a plea.
yes, he says, if court accepts me to have committed the offense,
Okay, do you want the further statement made in that matter? The further statement is, I
Hmm.
protested against the said act, but my uncle did not pay any heed and an altercation took place.
My lord.
Thereafter, I hit him and inflicted one blow for which I still repent. Anyway, that's only for 235.
yes, my lord, if it
Anything more, Mr. Any judgments to support your
judgment,
any law? Because you have taken you have taken some propositions. If you can also support that by judgments.
yes, Lord, my lord, lordship is very, my lord, liberal as far as me is concerned. Lordship granted time. And to be frank enough, my lord, we prepared the case up
Okay,
to late.
we got it. Yes, Mr. Borua.
We got some, my lord, decisions.
Huh, you
May
can
I,
give it.
may I furnish it, my lord?
Yeah, please.
Today, shall I?
No, now.
How, my lord, I'll get it photo statement.
You can just refer to that. What is that proposition?
My lord.
Okay, we'll hear Mr. Borua. Yes, Mr. Borua.
At that time, I'll refer.
My lord, the victim, my lord, who died, he was the paternal uncle of the accused person, my lord. Secondly, my lord, the motive for assault was that, my lord, my
Water.
lord, he was releasing the block water. At the same time, my lord, the accused was also working nearby and the victim was also working nearby. My lordship has already said, my lord, 3 witnesses, my eyewitnesses, PW1, 4 and 5, my lord. And a senior friend can overcome, my lord, these 3.
Because the medical evidence is that it is an heart attack, but there is a injury, internal injury found.
Injury found in the scalp is anti-mortem and
Mortem.
caused by blood impulse.
So that blow is corroborated.
My lord, what is the weapon used, my lord? Spade, my lord.
Spade,
Who
backside
shall
of
go
the spade.
Cutting, my lord, art, my lord. Secondly, my lord, the part of the body, my lord. That is the
Hmm.
vital part of the body, my lord.
Hmm.
My humble submission, my lord. This
By this, my lord, one point out.
Hmm.
Whether a spade can be, my lord, accepted so as to connect me with the offense. Spade was not even sent to my lord FSL.
You know,
And they made a contradictory statement.
FSL, there is no blood. There is no blood. There is no external injury.
Right.
So FSL will only tell that if there is a blood, whether that blood is yours.
And then, Manu,
There is no.
Even then
Why
there-
should it be sent?
there is a contradiction.
You show me any law that this is required that be blunt weapon when there is no external injury also.
It has
The
to
court must insist on FSL.
Then, my lord, today, Lordship is not going to tell you.
Not today, after this matter is being closed, no adjournment.
Oh, I'm not seeking any adjournment.
Then you give me.
I'm saying that, my lord, I will furnish the judgment to my lord court master today itself.
No, you can give it to me.
I'm just searching, my lord, because the new point Lordship has
This
raised.
is not a new point. This is a
Yes,
point
yes.
you raised.
This is for me, my lord. For the first time, this is pointed out, whether it is mandatory or not mandatory, unless and until a particular instrument is tainted with blood or etc.
Okay. Heard Mr. A.K. Purkaisto, Lana counsel for the appellant. Also heard Mr. Ajay Borua. Oh. Heard Mr. A.K. Purkaisto, along with Mr. M.K. Mojumdar, Lana counsel for the petitioner. For the appellant. Also heard Mr. Ajay Borua, learned additional public prosecutor appearing for the state respondents. Hearing concluded, registry to list this matter again on Mangalwar video. So, for delivery of others. Top of the list, it was in, no? Egita dia nasil unigi. Pakigita. Egita. Oh, 2 years. Madam, he is a town component. Madam, your matters are at 2 p.m. fixed. Okay. I thought you were waiting for that matter. Sorry. No, it's okay. Yes.
Your Lordship, my senior counsel, Mr. A. Sattar is in.
Mr. Mukit is there. We are not adjourning this matter. If it was there, you should have circulated a memo yesterday. I'm sorry. We have to make submissions, or we'll appoint an amicus curiae team. Not even a minute. If you had a problem that had not occasioned today morning, it was there. You could have circulated a memo yesterday. You did not. You made me read the file. Now I'm not adjourning it. You take it up in the point in the appellate court. Yes, you're not ready? Then you can move on. We'll appoint an amicus curiae. Mr. Mukit is there.
Then one.
Mr. Mukit is there. Mr. Sattar, I understand. Mr. Mukit is there. It's not that he is not there. He is there. And he was appearing also. Policeman, excess. Only thing you got to establish that you have a power of traffic control also. CRPF personnel. End of the matter. You establish that, I'll allow this. That's the only thing. I'm giving you time till the completion of the next 2 items. Thereafter, if there is none representing, I'll appoint an amicus curiae and proceed with the matter. You are appearing for whom? The informant. Okay. Sorry. If it is any other matter below item number 12, no problem for adjournment. But till item number 12 and the top of the list matter in supply, no adjournment. Yes, it's showing the High Court in a very bad light. Matters pending from 12, 13 and anytime it is listed, it is adjourned. Take an adjournment of. I'm sorry.
2 p.m.
No, we'll have it after some time. Once we finish after the top of the list matters, whenever it is completed, we will take up your matter. And if you're not there, we'll appoint an amicus curiae and proceed in the matter. Yes.
Here, my lord, in this case, the applicant was convicted under section 407 for a RI for 6 months lordship, along with 5,000 lordship, fine amount lordship.
Your case comes under 415. So penalty under 417 is done. Your promise, once she was caught with her family members, you took her to your sister's house. That shows that there was some understanding between you, a promise between you and the lady, victim. But thereafter you ditched her.
Your lordship may kindly see 2 judgments lordship, which I lordship. One is 1988, one GLR 128.
It's the latest decision of the Supreme Court. Came 2-3 days back on this point. We'll take care of that. But show me how you distinguish that your case is not covered by 415. 376 out of the way. So how it is not covered by 415? Just explain that. That'll do.
Yes, lord. My lord, the PW1 is the victim guard lordship. So I'm directly lordship come to the PW1.
Hmm.
PW1 in her deposition lordship.
Hmm.
May I read it lordship?
Hmm.
বছৰটো মই দিছো প্ৰপত্ৰ 1 হল মই দিয়া এজহাৰ প্ৰপত্ৰ 1 মোৰ সহি পদকে মিথুন কলিতাক মই চিনি পাওঁ একে গাঁৱৰে ৰাস্তাৰ ইপাৰ সিপাৰ ঘটনা হোৱা 1 বছৰ হল জেঠৰ মাহৰ 3 তাৰিখ সন্ধিয়া মই বালিজানাত সাপ্তাহিক বজাৰৰ পথাৰত বিহু চাবলৈ যাওঁ মোৰ বৌ হিকা বৰ্মন ও দাদা নিপেন বৰ্মন আমি একেলগে যাওঁ সেইদিনা মই বিহু চাই গোটেই ৰাতিপুৱা 4টামান বজাত মই মোৰ ভাতিজা ভাতিজীক ৰাজীৱ ডালিমাইৰ লগত ঘৰলৈ গুচি আহোঁ দাদা বৌ বিহু তলিত যায় ৰাজীৱ ও ডালিমীৰ ঘৰত হৈ মই অকলে ৰাজীৱহঁতৰ ঘৰত শুই থাকোঁতে মই পদকীয়াক মোবাইল নম্বৰ 44 ফোন কৰোঁ বিয়া কৰিবি নে নাই সুধো পিছত কয় মোবাইল নম্বৰ 44 পদকীয়া বিয়া পাতিম বুলি কয় পদকীয়া মোক পলুৱাই নিব বুলি কয় পিছদিনা ৰাতিপুৱা 10:30 বজাত মোক পলুৱাই দুধনৈ মোৰ বাইদেউ নিপ ৰাণীৰ ঘৰলৈ লৈ যায় তাত পদকীয়া মোৰ লগত সেইদিনা তাতে থাকে মই বাইদেউ ঘটনাৰ কথা কওঁ পিছদিনা ৰাতি
This is what I was telling. This is the act on your part in taking the girl from her house after the incident to your sister's house. Now, where is your explanation that some situation had arisen thereafter, for which you could not marry her?
So, because lordship, lordship, there is a contradictory statement, lordship. 161 as well as 164. Thereafter,
Did you comfort her with that?
Yes, lordship.
Where did you comfort her?
Lord, your lordship may kindly see first 161.
I'm forget it. So show me from the deposition that you had comforted her with that.
Yeah.
Mr. Kotogi. One assistance, one clarification. There is a 161 statement made by the witness, and the witness comes on the dock and makes a statement. Now, if there is any contradiction, that statement has to be put to the... Without that, you can't take a plea. Evidence Act, you will have to put it before the... And thereafter, the statement that comes out, you can say that there is a contradiction.
That has to be proved by the IO that he has made such statement before.
Proof IO and the witness had to be comforted, and that has to be clarified from the IO. Otherwise, that's it.
Draw attention to the.
Thank you. Yes.
They're in cross lordship.
Where is that material? Anything else?
Lordship. They are in the cross lordship. She, although that was a suggestion, lordship, সত্য নহয় পিছদিনাখন পদকীয়া মোক পলুৱাই দুধনৈৰ পৰা মোৰ বাইদেউৰ ঘৰলৈ নিয়া আছে লৰ্ডশ্বিপ that was her lordship sister, not my sister, lordship. তাত থকা নাছিল মোৰ লগত চয়নচ কৰা নাছিল ও পিছদিনা পলোৱা নাছিল সত্য নহয় বাইদেউৰ ঘৰত থাকোঁতে পদকীয়া মোৰ ইচ্ছাৰ বিৰুদ্ধে দৰ্শন কৰা বাইদেউৰ মোৰ চিঞৰ শুনি তাত অহা পদকীয়াৰ গালি পাৰাৰ কথা পুলিচক কোৱা নাই
That the sister, that is no. That is your elder sister.
Yes, lordship. But in lordship, the IO lordship, for the IO lordship, that was also not stated, lordship.
Where have you, why do you get things which are not there? You have not comforted her with that. The IO was not comforted with that. But what is the point?
Lordship, on that point, lordship, our honorable, your lordship, may kindly see these two judgments, lordship.
I think those judgments, Supreme Court latest decisions are there. Because it also has to do or not to do an act. 415, in addition to deceiving and property, has also this words. That has been interpreted.
Yeah, lordship, if your lordship.
I'm sorry. Yes, Mr. Burwa. Anything more to say? Yes.
The deception part, my lord, after the incident, my lord, the view function incident, my lord, he was taken to her sister's house, my lord. Again,
Her sister or his sister?
her sister, my
Her
lord.
sister, okay.
Her elder sister, my lord.
Hmm.
Then, my lord, she again asked her, my lord, whether you marry her or not, my lord. Next morning,
said-
my lord, he went off, my lord, without informing her, my lord. Wasn't, my lord? Deception, my lord, on the part of the accused person, my lord. But after that, my lord, he never used to, my lord, contact her, my lord, to give her.
And in 313, he has not explained that there was some circumstances which had come up for which he could not keep his promise. That explanation is not there. Anything more?
13, 14, and 15 of the judgment, my lord, there is the mentioned, my lord. There was it has been forbidden.
What are you doing now?
His lordship working in a company, private company. Her was already married, lordship.
Girl is married. Mr. Borwa, 12 years down the lane from the judgment. And also conviction is under 417. So it is or fine also. So we'll maintain the we maintain the conviction with fine. right?
I don't know.
This court can do. Dispose of. But you'll get these copies only next week, Monday, Tuesday.
All right.
How old is this man now? How old will he be?
13, I have to look into, my lord.
10% evidence to. LC. Very mosto to know.
2013, he was 52 years, my lord.
62.
Your lordship goes to the judgment, my lord. Basically, the whole case is based on the planning expert report. Yes, my lord.
That's the
That's of the matter.
crux.
Now,
But Mr. Kotogi,
yes, my lord.
Law does not also prevent the court from drawing if that is otherwise reliable. It can
Understand,
be,
but
it can be taken up. There is no corroboration otherwise required.
otherwise required, but because there is a judgment of apex court in Loebeck in Constitution bench, my lord. There it says, my lord, this,
I want those from you.
yes, my lord. There it says, my lord, that it is not a substantive evidence. So corroboration is the rule that has to be taken. Your lordship. Paragraph 21, my lord, last portion, my lord.
Para?
Para 21, my lord, last portion.
Hmm.
There your lordship file, last paragraph. Besides, it is necessary to observe experts' evidence as to the handwriting is the opinion evidence. Can rarely be ever take the place of a substantive evidence. Before acting on such evidence, usual to see if it is corroborated either by clear direct evidence or by circumstantial evidence. In present case, all probabilities are so and so. So there has to be corroboration, man, because it's not a substantive evidence.
But if we look into the circumstances here, okay, the chairman has been acquitted.
The chairman advisor has been acquitted.
And who, the person who you were with, the very account opening of the Samsher Ali is doubtful.
Doubtful meaning because it was the persons who has exhibited, they have identified there be no Samshed Ali.
No, that is the DW.
DW, no, the person, PW1, my lord.
PW1, he said that also that I had signed the form,
Yes.
the introduction form, but
Yes.
the Samsher Ali had not filled it up in my presence.
I understand, my lord. But fact remains, my lord, there is a person, Samshed Ali.
That's the mystery person.
Because we have received notice. We have filed high court.
Samsul had filed.
No, we have filed high court case against the Bakizai proceeding. Writ appeal was dismissed. So, really, there is a person named Samsul. He died, expired by.
92 he expired.
Yeah. So, It is not a case that without, there's no such person as Samsed Ali. Notice has been issued by CBI. He could not appear. His lawyer has appeared on that day because he was Ali, the lawyer has appeared. So the evidence that has come, it has proved that there is the existence of person Samsed Ali. And he was a contractor at that point of time. He has taken the loan, he has received the notice, the Pakistan proceeding notice. That is a fact that they have received a notice in his address.
Okay.
That Pakistan proceedings he has so
There is, and the learned trial court has said there is no direct evidence.
there is no so there is no circumstance
That is
against
para 22.
In fact, relying on the Supreme Court decision, our High Court also, in a PC Act, my case, my lord, has given.
No, it has said no direct evidence, only the examiner of question documents evidence.
Your cross-examination of the witness, your lordship said, if you go to the evidence of that witness, my lord, there also he has not, whatever scientific instruments he has.
That he has not disclosed.
So, and the characteristics, all the characters which I have asked him, he said, I did not do it. On what basis he has made the comparison? That has not been stated, my lord.
What does 1980 Supreme Court 531 say?
531, that is, 531 says that, yes, if there is a circumstances evidence is there, that court can compare it by using section 73, that part that is it. That is a 73 Supreme Court, but that's by exercise of power under 73 of the evidence, a court can compare it. That is exercise can be done, but that is a different issue.
But it also says that the uncorroborated evidence of the expert, if it is not disputed, can be.
We have disputed it, my lord. We have disputed it. That is the thing, we have disputed it. Okay.
So you are relying on 1964.
60, and that has been relied by our High Court also in another CBI case, my lord, that is on relying on this press court judgment, my lord, is a constitution bench judgment. The second point is that, my lord, the sanctioning authority, my lord. Here the board of directors is the sanctioning authority.
You are a sub staff.
Yes, but board of directors is the appointing authority.
Show me that.
That your lordship can. I'm just coming to you. At page 30, my lord. Ananda Bhuvan Das, my lord.
Page?
Page 30 of the paper book. I was the chief executive director of Ascot Bank from 1103 to.
You of the paper book or judgment, para 14.
No, paper book. There is a paper book, my lord.
Paper book is in. That is specially for Mr. Kotori, not for this court.
Officers.
Are. Can I just have a look at that?
9.
It's very helpful.
Yeah, I understand.
It index documents are index. Documents are index. It is also a mota to key. It did you. It all up algorithm. Careful already, but Page 30.
Yes, my lord. This is Ananda Bhushan Das, my lord. I was the Chief Executive Director of Ascot Bank from 1103 to October 2006. Being the Chief Executive Director, I was competent to remove Mokibur Rahman, Kion so. The CED of the bank was thus competent to remove a person from bank. The accused person Mokibur Rahman at the relevant time was working in the Ascot Bank as a peon attached to Imran Shah, that an advisor of Ascot Bank. Reasons of this removal has been mentioned in my sanction order. I have carefully gone through the materials placed before me by CBI, including statement of that can be your lordship word. Then comes to the cross-examination, my lord. Board of Directors is the supreme authority of policy decision in matter of removal and appointment of employees. She is to execute the decision of the Board of Directors. I did not mention exhibit about the approval of the board on the point of according sanction so and so. So it is not a fact that approval of board is required. It is not a fact without applying my. So he has admitted that is the approval of the board is required for removal of an employee.
No, means the initial thing, being the CD,
Yes,
I was competent to remove
I understand,
Makibur.
but the question is that the Board of Directors is the
For a
appointment.
substaff, normally it's not there. For the higher relation,
I understand, my lord,
it will be there.
But one line that is very that the at regarding removal and appointment. my lord, for removal and
No,
appointment.
it says that the question is what is the role maybe of the board, and it says that board of directors is the supreme authority for policy decision. Here there is no policy decision required for granting a sanction. Okay, but your other point we will have to hear, madam. Anything more, Mr.
No, because admittedly, by the judgment itself, the court has come to a finding there is no corroboration from any other evidence except the handling expert. That has, if your lordship goes to the judgment also, that the court has come to a specific finding, my lord. Paragraph last portion of the judgment, my lord.
On what point?
Regarding that there is no other evidence except the
Para 22.
yes, lord.
PW 19.
Okay.
There were other cases also of this appellant and the advisor pending at that point of time.
There's another case, my lord. There is regarding construction of the building.
The advisor is alive or he is
Expired.
expired? Okay. Anything more, Mr. Go to you.
I think, my lord, because already court has come to a finding, my lord, that
Para 22.
para 22.
We have noted that.
So there is no other evidence.
Mm.
And we of the decision of the apex court, my lord, is way back in 1964, my lord.
Mm.
And one should judgment, it is not a substantive evidence.
Mm.
Without corroboration, it cannot be found. So there is no corroboration directly or in sample submission, I may.
Yes, madam. What is your submission?
Coming to the expert. I don't have the paperwork.
I also did not have it when Mr. Kotogi showed, because this was somewhere in between. I could not find it out also. And I was under the impression that no paper books are made. Yes.
Not prepare properly, your lordship.
Then that is the bane of your client. I can't help it.
W19.
Hmm.
Elaborated in judgment at internal page number 9 of the judgment.
Hmm.
W19 Sri Nar W90 that along with the question document specimen writing of one Makibur Rahman marked as 38 to 53. So these are the specimens IU during the court investigation were received by the GEQ and is required to be compared by the question document. Question documents are account opening form, and check disbursement and his introducer card. And these are the question document which has been signed by the Makibur Rahman. And after telling that, according to the PW19, after comparing, they gave the opinion that the person who wrote the blue enclosed writing is stamped as Mark S. These are the specimen signature of signed as Samser Ali. Wrote the red enclosed writing similarly marked as question 139, question 1391, question 1392, question 140, question document 142, and question 203. This question document, along with the initial, are matching with the those of the specimen writing obtained by IO during the course of investigation. Those are from S38 to 553. And his loan has been sent for approval by the advisor. That apart, he has never purchased the vehicle. Able to produce the receipt. That has come in the PW11, Your Lordship.
That is by Samser Ali.
Purchased the vehicle and he could not able to produce the receipt in his loan file. Paper has been forwarded by the advisor himself. He is attached to the advisor.
How do you deal with the DWs?
PW he has expired and he has purchased the vehicle.
He has not purchased the vehicle. He had, in his
He
name,
has-
a loan was signed.
Yes, loan has been sanctioned, but he has failed to pay the loan. Because of that, Baki Jai proceeding has been. Even in the internal page, that has been discussed here also. In paragraph number 20, of the evidence, but we find no direct evidence to show that Makibur Rahman as Samser Ali obtained the loan from Ascot Bank. So no such document is that there. Ascot Bank for purchasing the Tata diesel. No any independent witness has stated anything to the effect. Rahman signed the loan application. So at the time of introducing the paper, it was blank. Exhibit 2/1 for the purpose of loan, and he availed the loan in the name of Samser Ali and used the loan amount without purchasing any vehicle. IO. He never purchased the vehicle. Visited the place of Islampur Mangaldoi, which is the address of Samser Ali, appearing in the loan document and other document of Ascot Bank. It is stated by PW20 that the and he could not trace out the Samser Ali. On the other hand, adducing evidence by way of examination W1 and DW2, the defense side has tried to prove it is the fact that there is a person named Samser Ali, a resident of Islampur, Mangaldoi, who availed the said loan. However, though from the evidence of DW1, it revealed that one Samsul Ali brought one recovery notice and there is a dispute with regard to the Samser Ali and Samsul Ali brought one recovery.
There is a dispute that as an investigating agency, you have to clarify. These are doubts being created which will go in favor of the accused.
Tried to prove that there is another Samser Ali, but in fact it is a Samsul Ali.
Samsul Ali.
Samsul Ali.
But Samsul Ali is not the one who has taken the loan. It's Samser Ali who has taken the loan.
Samser Ali has taken the loan in the name of Makibur. Makibur has taken the loan in the name of Samsul Ali.
But the finding of the court is Makibur has not taken that loan. Para 21, you just referred.
I'm going, it is also there. It is also. And DW2, the defense side has tried to prove the fact that there is a person named Samser Ali, a resident of Islam, to avail the said loan. However, though from the evidence of DW, it reveals that one Samsul Ali brought one recovery notice of the loan taken by late Samser Ali. not one recovery notice taken summarily issued by the Executive Director, Ascard Bank, and according to DW1, on perusal of the relevant record, he prepared a reply of the notice and submitted. But evidence of DW clearly shows that he does not know said summarily. Also, he prepared the reply on the basis of the letter received from bank. No instruction has been given to give the reply. Exhibit A on instruction furnished to him. So from the evidence of DW1, it simply transpired that he only prepared the reply of notice was sent to Samser Ali against the loan availed by him from the bank and does not know who is that Samser Ali. However, DW2 has claimed that he knows Samser Ali, a resident of Islampur, Baniapara, Mangaldoi, district Darang. And the said Samser Ali was a contractor. DW2 has also claimed in his evidence that Samser Ali Ascard Bank for an amount of rupees, and he showed Exhibit C letter of intimation dated 21. The date is also not matching. Disbursement, the date of disbursement of loan and the disbursement of loan to this person is not matching. Issued by the CED Ascard Bank. It is also contended by W2 that Samser a notice under section the CBI asked.
Ma'am, we have taken note of para 21. What is your submission on that?
This Samser Ali is different, or Samsul Ali. This is a totally different case. They are trying to believe that this Samser Ali has taken the loan. However, the Makibur has taken the loan and he has not repaid, and the receipt has also been not submitted in the loan paper showing the purchase of the vehicle. And GQD has amply justified that the signature is matching. Page number 20, from half of the handwriting expert has also exhibited the reason for his opinion. He has given the reason for his opinion, which is the concrete proof. And the handwriting expert has been fully cross-examined by the defense, though during cross-examination, the defense side has taken the plea that the opinion is wrong. And it is not based on any scientific method.
Okay.
But nothing significant has come from the evidence of the expert to disclose his evidence or to doubt the authenticity of the. As such, I find that the convincing and unsecond writing expert proved the allegation against accused Makibur Rahman, and in of the aforesaid observation, the apex court made.
Madam, I have noted it. I have noted it. Anything more?
Minimum punishment has been given. Based on the documentary evidence, this punishment has granted, and Makibur Rahman is there. His in writing he has obtained the loan, and for that purpose, he has been facilitated by the advisor also.
Why an appeal was not filed against the judgment against the advisor? Acquittal of the advisor by the CBI? Huh? Ma'am, you are the CBI. You should be aware.
I have been appointed.
If you are making that statement that the advisor is also involved in the matter, his acquittal should have been carried up on appeal before this court. Why was it not carried up on appeal? If that has not been carried on appeal, you can make no statement on that. Now the issue here boils down whether everybody agrees that it's only the QED, the expert opinion, whether that expert opinion can be taken on by itself or it requires a corroboration. Mr. Kotoki refers to 1964. What do you say on that?
Circumstances, we can come to the conclusion.
Okay.
Makibur Rahman.
Heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard Ms. M. Kumari, learned counsel appearing for the learned standing counsel, CBI appearing for the state. First up, hearing concluded, judgment reserved. এইখিনি ক'ত ভালকে থৈ দিবা, এইটো অলপ বান্ধি কেনে মোক দিবা। Yes, Mr. Krishna.
I have one request. Yesterday, I got this
We'll take it up at 2. Kindly go through it.
All right.
2 are customers. 2 customer witnesses. Then your superintendent, additional superintendent. 3. He gives the manner in which the account is to be done. 4. He has already paid 120 back.
Yes, that is.
He has already paid 120 back. Now you make your arguments on that. That's the only thing. Madam ko file did 2 o'clock, madam, we'll see.
All right.
I'm not adjourning. There was a mention made that she was not keeping well, but still I have not adjourned the matter. Not adjourning any matter. Or you can take an adjournment, time wastage, 25,000. Choice is for the advocates.
6.
May I please your lordship? Matter, the 13th never, my lord, was listed also, my lord. Notice also issued in the IA, but did not came up the party. Number 1, my lord, the issue is that, my lord.
Is the 1,000 rupees being continued to be paid?
Exactly. After in 2014, my lord, he was in touch with me that some amicable settlement is going to take place. Thereafter, no connection, nothing, my lord. I could not contact, my lord. Number 1. Number 2, my lord, when the local notice went to the
Both of them did not come. Both of them did not come.
My lord, because, my lord, what happened, my lord, kindly see the office note, my lord. He came with the return with a note that she left the place and not found.
Okay, fine.
Number 1. Number 2, my lord, in the case I have mentioned, there are title suit pending that she is not my wife. Only an agreement of to marriage, my lord, was there in 2009. And, because
Mister, are you paying the money or not?
I have not in touch since 2014.
Then we'll ask the police to inquire, if not to arrest him. Put him behind bars. He has violated the orders of this court.
I do not know exactly, my lord. I have not no connection.
Mr. Talra, we are sorry.
4 cases are pending, my lord.
These are, there is an order. You have taken an order in 16/8/23
I have
that you will continue to pay.
He was in touch.
So you forget it. We'll ask Mr. Borua to get that instruction from the jurisdictional police station.
No,
And if
not in touch, my lord.
If not, we'll
for
see
last
to that
12
he is
years.
put behind the bars.
Yes, my lord. Can be because not in touch. I have tried to contact.
You are not arguing.
My lord, no, I can argue, my lord, your lord. My lord, the thing is that, my lord, kindly see, my lord, there are 4 cases. Title suit is filed for declaring that I was
Mr. Talukdar, you are an expert. You have done much matters.
not expert. my
Here
lord.
it's only a prima facie view whether she is a wife or not. Those things you show me that in the trial court there has been a decision.
That is how at times you say, my lord. This case is pending. Whether I do not know that status.
But that will have got no bearing here.
I do not know. My lord. If it is declared that he is not my wife, my lord, I do not know.
Okay.
My lord, number 1, JJB case is pending. I am juvenile. I do not know the result. 498 is pending. My lord, domestic balance case pending at that time.
Let
But thereafter I do not
anything
know.
be pending in the world,
I
but
do not know, my-
125 is before me. I'll only concentrate on
It is up to your
125.
lordship. My
Okay,
lord.
fine.
My lord,
No argument?
I will pray for only for some time to.
No, no
we can
time.
Comment on.
Not anything.
My
No
lord,
time.
My lord, if
You had time
if she is
till
the
from-
wife, my lord, if she
you
is the
had,
wife,
Mr. Talukdar, you had time from 22 when the last matter was last listed.
very much true, your lordship. But thing is that he is not my lord. Only thing is that whether he is wife, she is wife or not. It is matter of 1,000. This cannot be lessened anymore, my lord. Nothing to be lessened.
And
less than
that 1,000 is also
Yes.
not being paid to that destitute lady.
My lord, at that time it was, I informed him, he was one.
I don't have
he
the
was-
power.
He was paying.
I don't have the power, otherwise I would have increased this amount.
But what is this? I have not been in touch with since then. Well, I cannot say exactly what.
I'll record your statement that you are not in touch with him, so you are not in a position to make your arguments.
I can, my can say that only that she is not my wife. As I have filed the TS, I have filed the JJB case,
Mr.
but
Talukdar,
nothing more.
Mr.
than this.
Talukdar, either make an argument on merit or say that you are not aware today about the facts. So we'll record and we'll proceed.
My lord, only issue is there here, my lord. That she is my wife or not. If she is wife, it is very minimum amount, my lord. 1,000 what
Mr.
can.
Counsel, that is not the concern of this court.
Not like the situation of these 4 cases, they are not in touch with me since then.
Can't help
My
it.
lord, let it be taken at 2 so that may I make another attempt to make
No, no.
some connection.
You have tried,
Tried,
rejected,
tried.
but it does not go inside the court. What to do?
Even the, my lord, came back, my lord.
Mr. Kotoge, again, I'm troubling you. In a 125 proceeding, which was there verdict in 2012. This court also said continue payment. Now, for after 2,000 rupees only. Now, does this court have power to sumoto take up 127 and enhance? It does not have, I suppose.
Division court, my lord.
No, this is a revision. I will not have that power.
Court of division power is there, but
But no, in a proceeding, I cannot pass an order, I suppose.
1,000. But whether they are surviving, whether they all.
How do I get to know whether this amount is being paid? The lady is not being represented here.
he has not been represented. Notice has to go to the lady, my lord.
Thank you.
The local police station notice can be.
Local police station.
No local police station, my lord. Then be sure, my lord, what is the status?
Be a better option, my lord.
Hmm.
Actually.
Yes, Mr. Goswami. Can you get this instruction? Huh? The local police station would be Hazara, Kamalpur, PS Kamalpur, in the district of Kamrup. Oh, it's nearby.
Action will be as regards, my lord, whether
The amount is being paid or not, or whether there is some other developments taking place in the matter.
there is a case pending that also
Civil cases pending.
Four cases, my lord, as far as. For title suite.
And if the man is not paying the money, we'll have to get him here. But first you give me that instruction. Can I have it by Monday? Tuesday? Monday. Tuesday. Mr. A.K. Talukdar, Learned Counsel for the petitioner. And Ms. M. Medhi, Learned Counsel for the respondent number 2, not Nam Defaisani. PPS. Only PPS. Yet কিন্তু respondent number 2 দেখাই আছে। এইটো ক'ত থাকে ওকালত তোমাৰ ৰেছপন্ডেণ্টৰ এপিন থাকিব নেকি?
starting, my lord.
Huh? Party, she's a party, but there was an advocate also appearing.
In this case, my lord, notice was issued, my lord.
Huh?
It is also sent, my lord, in
Ah.
this case, in this case for condonation. But it is not, no comment whether it served or not, or came back, nothing.
Okay. Mr. A.K. Talukdar, Learned Counsel for the petitioner, has submitted that he has lost touch with the petitioner in the matter and accordingly is not aware as to regards the present situation, present status of the relation between the petitioner and the respondent herein. Also, he is also not in a position to apprise this court as to whether the maintenance amount which passed by the learned trial court was continued to be paid by the petitioner to the respondent in terms of the directions passed by this court in the present proceedings, wide order dated 16/8/2013. Full stop. In view of the above situation, Mr. M.P. Goswami, Learned Additional Public Prosecutor, shall cause an inquiry into the matter through the, shall require the jurisdiction officer in charge, jurisdictional police station where the respondent resides to cause an inquiry as to whether the respondent is receiving the monthly maintenance as awarded to her as granted to her by the learned trial court and which was directed to be continued to be paid by this court by order dated 16/8/2013. For so the inquiry will also the officer in charge also shall also examine the respondent with regard to the outcome of the other proceedings instituted by and between the parties to the present proceedings. So registry to list this matter again on
18, Lordship.
18 for further hearing. Copy of that.
My lord, maybe on 19, my lord. Or before that, 17, my lord, 16, my lord.
18, you have some problem.
Yes, my lord.
Okay, 19 further hearing.
Really, my prayer is that, my lord, can a notice be issued to the respondent so that regarding pendency of the case?
No, you just get this. Mr. Talukdar is there. We'll work out something. You get this. Get this instruction.
Yes, my lord.
May please, Your Lordship. Whereby I was convicted under section 364, my lord. Originally, it was 376, my lord. For evidence, it appears that he is a consenting party. Case of 354.
The evidence of the victim and when read with that Rajesh Mudra
Yes, my lord.
consenting.
He had seen it, that's why it was informed to the.
It informed it and there was no hue and cry even when he came.
Yeah.
And the other witnesses have also not said that there was a hue and cry, although their houses are nearby. Yes, Mr. Goswami.
Not concede, my lord, but
But Mr. P. Kotugi, learned counsel for the petitioner, also heard Mr. M.P. Goswami, learned counsel for the respondent. What's up? Allowed. Mr. M.P. Goswami. Ligis na? Ito khali tar nilihiba mo dictation to reading. Are you receiving that money? Has it been completely paid? Completely paid.
That the petitioner has died, that I have got.
Can I record your statement to that effect? Both that the petitioner has died and you have received the complete awarded
So
money.
far the deity is concerned, my lord can by the same by the registry.
Huh?
The other party is not here, my lord.
Whether you have received the full amount?
I received.
Full amount.
For the sentencing part is concerned, my lord. Part is concerned, my lord, whether.
No, if that man is not alive, otherwise if the money
that's
is
right.
paid, I could have
My lord, that's
done away with that, the, what do you call that, the imprisonment. Who is Mr. S.A. Loskor is there? Can you get hold of Mr. S.A. Loskor? S. Roy, R.C. Paul, I have not seen him for a long time. R.C. Paul is here somewhere. He'll be here. Just check up. Ask your junior. You need not be here. Your junior will be here. We'll have it in the second half. You just get hold of them.
my lord.
Yes, my lord, against the judgment and order, in passed by the additional session, Kamrup at Guwahati, passed in session case number 369 of 2011, whereby convicting the appellant and to
Your voice is wavering. I think you are not in a position. heard Ms. N.S. Taguria, learned counsel for the petitioner at some length. The hearing remains inconclusive. Raised to list this matter again on Putwater Woodburn. So now I have heard you. I can adjourn the matter.
Offline.
Yeah, my lord.
Hmm.
First time under section my lord 376 and my lord 417, my lord. And since my lord from the evidence of the my lord informant victim, it appears my lord she was a my lord consenting under section 417.
This is item number?
Item 10.
Okay, 415,
415, my lord, and conviction
417. Yes, what do you have to say?
from the my lord judgment, my lord, it appears my lord in the Person of Offender Act, my lord, that was my lord not considered, my lord.
So what is the current status of the lady and the boy? Hmm?
Villain, my lord. Time of my lord, alleged incident, my lord, both were my lord 24 years of age, my lord.
Hmm. Hmm. Okay. Anything more? Fine. We'll limit it to the fine. Imprisonment, we are not modifying it.
Here, my lord, judgment, my lord. It's here and it says judgment, my lord, discussed everything, my lord.
2012,
My lord.
2013, today around 12 years. Why did you keep this matter pending here for such a long time? It's a pain. He'll pay the fine. This mine will be deposited before the trial court. He'll pay the fine in terms of the decision, but we are condoning the 6 months imprisonment.
Yes.
If you have something to say, please guide me. If you have
No,
something.
regarding the merit part, I am just.
Merit conviction, appel. Conviction is appel.
Conviction.
Appel.
Other your lordship's discussion, my lord.
Conviction appel. Yes, Mr. Counsel.
Okay, Burwa, my lord.
Anything to say?
The point of my lord, probation of on my lord, but since
No.
your lordship has my lord reduced to my lord
Cannot be.
fine only, my lord, then my lord.
This is not a case against a girl, lady, will not. Probation offenders will not come, but I'll do that. 6 months I'm removing. 20,000 fine. Pay. Ke Burwa. नाम कितना लिखता है?
May I please, Lord? It is the case for quashing of the proceeding.
What happened to that 340 packets of beer?
No, my lord, that order has been passed by the deputy commissioner after pursuance to the High Court's order, my lord, and he did not turn up, so accordingly,
Which
there
one?
is no such 340 beer as alleged.
But there is a doubt. There is some materials which shows that there is a.
No, my lord, I'll show, my lord, if your lordship permit me, I'll just read it out. Firstly, my lord, I'd like to apprise the court, my lord, that, my lord, I lodged a complaint against the particular office.
And that is the second case.
My lord, that I'm coming, my lord.
Second
Why
case,
he subject to
the second case is with regard to sanction.
Yes, my lord.
So I think that without sanction, how can you proceed? Because
That
that
I'll
is
come, my
done.
lord, that I have come with the apex court judgment, my lord. That I'll come, my lord.
Yes.
First, my
What
lord,
happened?
First, one thing,
Seeking some,
No. Why time?
1 week may be given, my.
Why? For what? It has come up. Why have you not been active in getting this matter heard before? It's your thing that has been blocked. There is an interim order. Whole investigation is blocked. She is still in service.
So retired on 31st July 2023. Got retired, my lord. Nutshell is like that, my lord. I'll just,
Fair and
I don't like nutshells. I like the complete shell.
yes, my lord, complete, my lord. I'll just,
Coconut one.
yes, my
Be
lord, I'll
nuts.
just give it to you.
Yes, Mr. Bora, you look very serious. Something. Oh, item 12, 13,
No, no.
12, man.
12, 12.
For the private respondent number 2, I am appearing, man.
Oh, that sanction part.
Yes, man. Not
He says he has a judgment. Let us see what the judgment is.
apart from the judgment, my lord, before going into the judgment, my lord, go by the avertments in the complaint. There's absolutely nothing against me, my lord.
No, even if we hold that there is something against you, what is the error in the decision of the trial court that without a sanction, he has done that in his official capacity,
Yes,
we
absolutely.
cannot do.
Yes.
And he had done it because the deputy commissioner had required him to do it.
Not like that at all, my lord.
Not like that.
Not like that at all. Like, permit me, my lord. If your lordship kindly take up the matter, my lord. First matter, my lord. Why it's subjected to the CID case, my lord?
No, we don't want to put Mr. Borthakur into trouble because this
Both are the
matter,
interlinked, my lord.
we'll have it on Thursday. Any problem on next Thursday?
My matter may be taken up, my lord. I think
There is nothing here, but both are connected. He is making a submission.
Interlinked, my lord.
next month, this is a CR.
I'm satisfied with that. Don't worry about it. Only the order is deferred. Subject to Mr. Bhuya showing me something. 18.
18.
18. As prayed for by Mr. I. Borthakur, Learned Standing Counsel, Excise Department, the matters be listed again on 18/9/2025. No further adjournment would be granted in the matter.
Otherwise, I was prepared. I have prepared. my
You
lord.
are always.
Inform me, my lord, last night.
It's always. Mr. Bhuya, the problem is you also sometimes come out of the blue, make an argument, make a prayer for adjournment. This court also comes prepared. It also has to, not prepared, but it has to go through that.
Last night.
But you also don't tell us this court that I'm taking an adjournment. So these things go on in this thing.
Accept
So
it.
don't exaggerate them.
Accept.
ये तो oh.
May I please, Lordship? My lord, the matter was only for one point, that blood stain clothes was not seized by police. Kindly see the evidence of Iman Ali. That is the driver, who is the victim of this case. His statement may be seen. After no
PW?
para is there.
PW?
PW 3. Only go after pages, you see. Here,
PW3. Yes, what do you want to say?
মই গাড়ীত বহি থকা অৱস্থাত মোক মাৰিছিল.
Where are you reading?
There is no page, but it is a statement of PW3.
I know that. Which part? Starting is something else. Cross or
Cross part.
I have that. Just okay. Yeah.
Top of the page.
Hmm. Yes.
So it is seen that the police has looked into his injuries. The injuries were grievous injuries. And all his bodies as well as clothes, etc., were blood stained. But he said all this, and the police also looked all this, but did not seize those clothes, blood stained clothes, and nor do they send the same for forensic examination. Now, the Honorable Supreme Court says that is 2020, 15 SCC 310, para 13 and 18. I read well.
That was seized but not sent for FSR.
Yes. Here, two aspects of the prosecution case. The defective investigation, they did not seize it.
And what is the
And-
decision you want to rely upon, Mr. Monmouth?
That is 2020
Hmm.
in SCC
Hmm.
310,
Hmm.
para 13 and 18.
What does it say?
Yes. Here it says, and Ramesh Elias, I am reading only the relevant portion. And Ramesh Elias, para 13, Ramaya accused for were apparently kidding
Hmm.
with them
Hmm.
and had used in the commission of the crime
Hmm.
has not been satisfactorily proved by the prosecution.
Hmm.
The evidence of one's witness, that is Chandrasekhar, son of so-and-so,
Hmm.
and so-and-so,
Hmm.
clearly shows that they were called to the police station and the jewelry items, cash, knives, etc., were already there on display.
Hmm.
How and in what manner the recovery was made has not been brought on record by the prosecution.
Hmm.
And we therefore hold that the prosecution on the basis of evidence of PW 6, 7, and 20 has succeeded in proving the case so far as Alia, appellant number 2, accused is concerned. However, taking into account the circumstances in which the crime was committed
Hmm.
and the fact that charges against 3 of the co-accused have failed, we are of the view that the sentence imposed on appellant number 2 accused would require modification. Having considered the matter, we take the view that the sentence of death imposed so-and-so against appellant number 2 ought to be commuted to one of life imprisonment. So the death sentence was converted into life imprisonment because the knife, etc., jewelry, etc., were there, but why they did not seize it, there was no clear explanation from.
Okay. Okay. Anything
Second
more?
thing, my lord, can
Anything
you
more?
see the judgment?
Hmm?
This is I will not. give so
Another
much time.
judgment?
The judgment of the learned court,
Huh, huh.
page 18, can you see? Page 18 bottom.
Hmm. Yes, Mr. Monmouth.
Here in this case, we find that there was more than one person involved in the alleged incident, and all of them caused hurt to victim with a dagger. From the evidence, it can be well interfered that the accused person deliberately and voluntarily caused hurt to the injured. So, everywhere it is there that 3 persons with common intention to take the vehicle continuously step the PW3, the injured driver. But here conviction is only against one, Chandra Kumar Das. Now, prosecution has not come with clear explanation
Why the other two?
Where these two other persons have gone. So prosecution's case is bad, imperfect, and investigation is totally unfair and motivated. So my submission is this: on the basis of two judgments, the present appellant may be acquitted. Alternatively, Lordship may kindly make it into fine only. Because 2006 case, now 2025, that is 19 years. Now he has become the father of children, etc. Some grandson is also there. In such a situation, if he again has to go to jail, then it is very much painful and pathetic. For these two reasons mainly, either acquittal or converting into fine.
Mr. Mahmood, that two other persons, there is an explanation. Those two are juveniles.
Huh?
Juveniles.
Juveniles, well, that is
That is why they are not here. They are before the juvenile board. They are juveniles. If you want to have a reference to that, go to the first paragraph of the judgment.
then I would do that part. That part I don't. If they are juvenile, automatically they will go juvenile court. But thing is this.
Just see. Why believe the court? You get yourself acquainted. First paragraph, I suppose.
I have not seen actually.
Charge sheet against 3. The record also you'll find charge sheet against 3.
Yeah.
But those two are juveniles, right?
Request person with letter and approach. Police. There are
Right? No. Other two are juveniles.
juveniles.
Yes, Mr. Goswami, what do you have to say? No, tell me.
Next court also, my lord. His statement has to be, my lord,
Given.
as it is not at par with witness because it is more than that, my lord, because she is a big and has made
Prosecutrix, victim, these are stands on a different pedestal altogether.
lordship, that your lordships, my lord.
And at that point of time, there was none other than that petition. And these people could be caught only because there was an accident of that.
There was an accident, they have fled with the car. So 394, they were convicted, my lord. And it is also not disputed, my lord, and it is also from the evidence, it is clear that, my lord, they have hired this vehicle, my lord. Hired it
From the owner, and he was the driver.
Yes. And so, my lord, nobody was there in, my lord, instead of these 3 persons, my lord. In between, they stabbed him and took the car and fled away. But the village, they met with an accident and villagers cut them, my lord. Very clear. My lord. And from the IO's evidence also, my lord, it is very clear and it is cannot be, my lord, demolished, my lord. They were caught by the IO, my lord.
No, they were caught by the villagers and then
No, my
handed
lord,
over.
villagers, after that, my lord, handed over to the IO, my lord. It is. And from the, my lord, and this was corroborated by the doctor's evidence, my lord. That is stab injury and the lacerated injury, my lord, by sharp weapon, my lord. It is very much clear. So as per my lord, my humble submission, my lord, it is rightly convicted 324 and 394, my lord. Was stabbed, my lord, it could have been 307 also, my lord. Had it not, he had fled, my lord, by the, if not
The matter right to reply. Actually, my intention was not that about the quality of the evidence of PW3 that the injured person. My legal point is only that when there were blood stained clothes,
Why that was not
it was
covered?
not seized, number one. Secondly, why it was not sent for forensic examination.
We have
This
noted.
is the investigation defect. So investigation's defect
Should go to the accused, not to the not to the prosecution, but to the accused.
To the accused will get the benefit if there is any lacuna in the investigation.
Right.
That is the Supreme Court said. There are so many judgments of like this. I have only brought one because very old case. So that is also one of the grounds. Old case, lacuna in the investigation, and hardly, my lord, the
We have noted that. Mr.
conviction may be.
We'll try. But Mr. M.U. Mahmood, learned counsel for the petitioner, also heard Mr. M.P. Goswami, learned counsel for the learned additional public prosecutor. Hearing concluded, judgment reserved. Take a 10-minute break. We are coming back.
All right.
Ajo, 10 minutes লগছি 10 minutes.
What is the error?
Pardon me.
You say that even if it is the second notice,
Yes,
then it would be still barred by.
yes, that is my case.
When was the case filed?
Uh,
Complaint filed?
26/7/2000. Is what e-court shows a website, but judgment mentions is 23/7. But even if it is 23, it is still barred.
And they got the information from the postal department on. Okay. Let us see the provisions. I mean. You say if it is, the information was received on 15/6/2017, but the complaint was filed only on 23/6/2017.
So even if we give a reasonable
9 to
time
9.
for service of it's
Still to.
reasonable time for service of notice has to be 1 month. And if it is given, then in that case also more than 29.
And you rely on a Calcutta judgment for that.
Yes. Apart from the Kolkata judgment, the law is clear, my lord, that starts from after the expiry of 15 date from the service of notice. Knowledge is not
Yes. One.
is made within one cause of action arises. So say
Where is the complaint? Petition.
complaint I have not announced.
You have a copy?
Right. Immediately notice was served on 6/3/2017. Yes.
Heard Mr. O. Laskar, learned counsel for the petitioner. So, the present criminal revision petition is instituted assailing an order dated assailing the impugned judgment and order dated 5/7/2019 passed by the Additional Chief Judicial Magistrate Kachar Silchar in CR bracketed NI bracket over 120/2017 directing the petitioner herein to sentencing the petitioner herein to undergo simple imprisonment for 2 years and to pay a fine of the double fine at the rate of fine double the amount of the check in question, that is an amount of rupees 2,10,178 for an offence committed under section 138 of the Negotiable Instruments Act 1881. Also, the present petition also assails the judgment and order dated 28/7/2025 passed by the Additional Session Judge FTC at Kachar Silchar, Assam in Criminal Appeal number 27/2029 upholding the judgment of the trial court. Also, Mr. O. Laskar, learned counsel for the petitioner, has submitted that the proceedings before the learned trial court was so instituted by the respondent herein much after the lapse of the period of limitation as prescribed under the provisions of section 142 of the Negotiable Instruments Act 1881. Also, upon hearing the learned counsel for the petitioner as well as perusing the materials coming on record, this court is of the considered view that the matter requires a closer examination. Also, accordingly, closer examination. Full stop. Issue notice to likhison report. Issue notice returnable 4 weeks. Petitioner to take steps for service of notice upon the respondent, sole respondent, by way of registered post with AD. Full stop. Till the next returnable date, the impugned judgment and order dated 5/7/2019 passed by the Additional Chief Judicial Magistrate Kachar, Silchar in wide judge till the returnable date, the judgment dated 5/7/2019 passed by the Additional Chief Judicial Magistrate Kachar Silchar, Silchar in CR bracketed NI 120/2017 and the judgment dated 28/7/2025 passed by the learned Additional Session Judge, FTC Kachar Silchar in Criminal Appeal number 27/2019 shall remain suspended. Further, the interim order would be further considered on the appearance of the respondent number, on the sole respondent. A copy to DD. Take back the copy.
Yes, there. They may be disposed of in town.
In view of the order passed today in criminal revision petition 367/2025, no further order is called for to be passed in the present interlocutory application, and accordingly the same stands closed.
Highly obliged.
Order. Yes, madam.
From the FIR, the incidents took place.
Your name? Yes? Sony Chaudhary. Yes.
The FIR, it's in that the incidents place, your lordship on 17/8/2007, Your Honor. But the FIR was filed after 6 days, lordship. That is on 23/8/2017, 2007. Lordship.
FIR was filed on?
23/8/2007. Lordship. And in the FIR, there is no mentions regarding the delay.
I'll add one more thing here. The FIR was filed in Panbaja police station, whereas the offense took place under the Phorolumuk police station. Right?
Yes.
Then.
Regarding the story projected by the informant, your lordships. Secondly, lordships, the matter was investigated by the offensive was a police outpost, lordships, and thereafter though the offensive was a police outpost has no jurisdictions, thereafter the matter was transferred to the Phorolumuk police station, and the Phorolumuk lordships at the Phorolumuk police stations. Police stations did not investigate the matter, and without investigating the matter, filed the search sheet, lordships, on the basis of the investigation carried and conducted by the Fancy Bazaar police outpost, lordships. Thirdly, lordships, the material witnesses are not examined, such as the domestic help of the informant.
Slowly. You're doing it right. Slowly.
Sri Rao Patil and Sri Shiv Singh, lordship. And fourthly, Your Honor, the informant. There are 3 independent witnesses, lordships. That is PW2, PW3, and PW5, and they don't have seen the incidents, lordship. Fourthly, lordship, the PW4. 4 is the medical officer, lordships. Though he had came to the court, lordships, and examined and exhibited the report, but the same documents which he has been exhibited is, that is, this exhibit 2 is devoid of OPD register number, X-ray report, X-ray plate number. Fourthly, the medical examinations of the informant was not examined by the police station, lordship. And the informant has failed to show that there are wrongful restraints by the accused persons, and there are grievous hurt caused to him by the accused persons. So
You're on the line. Prepare well. Come back on Monday. But you will have to do the matter. This much I want from you. We'll adjourn the matter. We'll give her some time. She is trying to make out a case. Let's see. These things have been dealt with, but let us see whether she can make out something. Right? At least for probation of that Offenders Act, you bring your case within that. We are here. We'll help you. But Ms. S. Chaudhary, Learned Counsel for the petitioner, who has made her submissions in the matter on behalf of the petitioner. Full stop. Ms. Chaudhary submits that she be given a day's time to prepare the matter further and make her submissions in the matter. Prayer accepted. Registry to list this matter again on on 17 9/2025 as the first item for further hearing. You now prepare. Madam, it's very easy to come and take time, but time taking is this way. You prepare, you show us that you have done something, we will give you time. No problem. You get well, come back, but I'll not hear anybody else. They can assist you, but they will not make submission. You will make submissions. Yes? No, she'll get an advocate along with her. She'll get an advocate. You get somebody who is there in the matter on the next day, but we'll hear you only. You are amicus curiae, no? Yes. Duta. Itu dutan mati badi. এটা ইয়া পঠাই দিবা RC Paul SR Roy SA Loskor টিকা এটা পঠাই দিয়া মাতি দিয়া নহলে Yes.
Chief, I've been appointed amicus in this matter. And the matter relates to quashing of a proceeding. What had happened? The Lordship comes to page 10. It's a tenancy dispute that had culminated into a fire. Page 10 is the complaint, my lord. But on 13/11/2011, it has been alleged that the petitioners herein have assaulted and thrown away this respondent number 1 from the rented house. Incident is of 13/11/2011. She has lodged this complaint before the CJM on 16/11/2011. There she has stated, if your lordship comes to page 5, paragraph 5, page 11 of the complaint. Para 5 at page 11. She states that the complainant begs to state that the accused person stole away 5,000 rupees from the bag kept inside the pillow. Moreover, all utensils like bell metal, disc numbering, 3 bowls, teapot, cup plate, saris, blouse, petticoat, almirah, fridge, TV, gold ornaments, silver ornaments were all thrown out from the house. He admits that these were thrown out from the house. That is our allegation. Now, on the next page, my lord, page 12.
Just a second. This is criminal petition 168. Her prayer here is, what is the prayer here?
Page 7 is a prayer. All
Okay.
set aside and quash the complaint case number so and so, pending in the court of Judicial Magistrate First Class, Kamrup at Guwahati.
Binu Kolita. Okay.
3 petitioners. 3 petitioners.
So you say that para 10, page 11, para 5, that is the grievance.
That is the grievance. Now she at page 12, my lord, she states the accused persons are dangerous.
156.3.
156.3. She states dangerous in nature, desperate character. They even did not give us time to change my room. I have lost lakhs of rupees for being thrown out of my property. There she says 5,000. Same paragraph she says lakhs of rupees. My submission, my lord.
No, lakhs of rupees is with regard to the other broken and all. It's an exaggeration maybe.
Whatever, my lord. Why I'm stating, my lord, this is subsequently this was sent to
police station for investigation. After investigation, police gave closure report. That is at page 14, annexure 2. That is a type copy, my lord.
FR given.
FR is dated 31/12/2011. After 1 month, 15 days. Lordship comes to page 15, 1-5. Page 15, it is said, at the time of investigation, visited the place of occurrence and taken statements from the witness, and accordingly, all articles mentioned in FIR has been deposited to the informant in presence of our police and local villagers. When made inquiry to the informant, she declared that due to non-checking of property and misunderstanding, she has filed a case, and also declared that the landowner and tenant are mutually compromised the matter in presence of the villagers. The basis of this, FR was given, the compromise. When the matter was, when the FR was sent to the CJM, she filed an Naraji petition. The basis of the Naraji petition, CJM Judicial Magistrate passed this order at page 18, annexure 3. Dated 18/10/2012. CR put up with petition number so-and-so filed by informant. Seen the petition, Perus CR also gone to the connected CD. The informant has raised objection against the FR submitted therein. Objection in this on its acceptance. On considering the submission and materials available before me, FR submitted is rejected. Complaint petition is available on record to be registered as complaint case. And summons were issued to me.
Okay.
On the basis of this, this petition was filed. Now, my lord, if your lordship goes to the order sheet, there is even paper publication in respect of respondent number 1, the informant or the complainant. She has never entered appearance here. From 5/1/2015 to 15/12/2015. In fact, my lord, this honorable court had directed the CGM to take serve notice on the informant through the CGM's office. A copy was handed over to the counsel who had appeared for the informant there. Court had said that cannot be a service. So subsequently, paper publication was done. In fact, paper publication affidavit is at flag D, my lord. Till this date, she has not
come.
And my lord, when I have gone through the case records, one of the earlier orders says that interim will be considered on the when respondent number 1 appears, but there's no interim order. Subsequently, by order dated 2/8/2023, my lord, it was stated that if any interim, it was vacated and a report was called for from the CR. What is the status? But I could not find anything on record.
Where do you get that in this present proceedings?
Yes, 2/8/2023. Order dated 2/8/2023.
This report has also not come.
I could not find, subject to correction, I could not find.
So should we take direct the registry to get a report, because here says status report has not been received by the section till date. Okay. This is from where?
Kamrup.
Heard Mr. D.K. Bhattacharya, learned counsel, learned counsel, learned amicus curiae, appearing in the matter. Full stop. On a perusal of the materials brought on record, this court has found that while order dated 2/8/2023 in the present proceedings, passed in the present proceedings by this court, the registry was directed to obtain a status report with regard to the complaint case being CR case number 2353 3 small c oblique 2012 from the Court of the Learned Chief Judicial Magistrate
No, my lord.
Kamrup,
Judicial Magistrate First Class, Kamrup Metro.
from the Court of the Judicial, we say Chief Judicial Magistrate Kamrup Guwahati. Full stop. The office note dated 15/5/25 reflects that the office note dated 15/5/25 reveals that the said report was not received till that date. However, thereafter, there is no update with regard to the said aspect of the matter by the registry. Also, accordingly, registry to obtain the said status report and place the same before this court on the next date of listing. Full stop. Registry to list this matter again on when it will be convenient to you. Let us have it on 19th or 22nd. Let us have it on 19th. 19/9/2022. Full stop. Etu keneka tane gom pabo? Etu koi diba niki? Ei order to kotha koi diba niki eba? Joint register section or register judicial ba joint register judicial level. Ite koi diba.
Right.
Misplace our brief, my lord. Reconstructing our brief, my lord.
Don't ask time from this court. Time means till 4:45. Yes, what is the case?
This is the order dated 19/2/2006. Against the imprisonment of 20 days under fine 1,427 of 500 and imprisonment for 10 days. Lord.
Come to the order of the trial court. E79 427/34.
Or 39.
Yes, what is your ground?
Exer C Lordship 39 page number. There is a police report. The case of 10 dispute Lordship.
But your presence there is established. Okay. Your name? Heard
Behalf
Mr.
of
B.
B.
Dr. Lana counsel for the petition. Also heard Mr.
A Gayan on behalf of PK Munir.
Also heard Mr. A. Gayan, learned counsel appearing for the respondent. So, Mr. B. Doctor has made his submissions in the matter. However, Mr. B. A. Gayan, learned counsel for the respondent submits that he be given 2 days time to reconstruct his records, his brief. So, prayer accepted, registry to list this matter again on 16/9/2025 for Keta Sedna. 16/9/2025 for further hearing. Now, is there anything on record to show that he has received exhibit 4? Rupa has received, but Thirmal has not said anything about that. We are on Thirmal now. In this now, we are only on Thirmal. The question of he referring the matter to the police will not come. Because that is by that lady and Rupak. Okay, what is your submission, madam? Just indicate the PW you want to refer and make your submissions.
Sahib Tila.
Hmm. 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 That is with Rupa Gugui, not with Trimal Talukdar. Yes. বুঝছো? যিকেইটা হৈছে সেইখিনি আপলোড কৰি দিয়া।
By the counter.
Okay, fine. That is Rupak Kumar Gugui. Where is the I mean, madam, what I want you place that, but what I want is where is the material connecting thermal with the other two accused, the dealing assistant and SN, what is his name? SN Mojumdar. That is Rupak. Not Tirmal Talukdar. So Tirmal Talukdar, he has accepted this application. There were some errors there. But where is the material to connect him with Rupak Gugui and SN, the conspiracy? Hmm. Is that ladies? She put a question mark. That is with Rupak to Rupak. Madam, the plea that he can take is, Tirmal, that when I received these documents along with the originals, it was not possible for me to hold that these are forged documents. This forgery would have come out if the matter had gone to the police. So he bona fidely accepted that application and he put it up before the next authority. So what I want to know is, where is the material connecting him with the conspiracy? That is Rupak. That is Rupak, not he. That is A3, not A4. Huh? PW8. Page 13 of A4. The receipt of the application. That much is there. in that 39 certificate also his initial is there. His signature is not there.
Before.
Exhibit 4. Where is his signature in Exhibit 4?
The question yesterday. PWs also, there is no mentioning. I have received it.
Okay. Now, madam, have this. Now compare that with the question documents. There are two questions there. Question number 16 and 2 are there. One is Amarnath, it is rounded. Q16. And one more is the Amarnath is also there. Talukdar it is written. Talukdar it is written. Okay. Now 16. Now exhibit file is আৰু এক্সিবিট ফাইল নাই, এইটোৱে আছে ন? বেলেগটো নাই, এইটোৱে আছে। পাইছো নহ'ব নালাগে। দেউলক। Q16 is the whole document. And that has been held to be written by Amarnath, and the signature both have been said to be by the Tirmal. Okay. Anything more, ma'am? That we'll hear, then come back to you. So this does with, huh? Court witness. Evidence to some. Some Loknath or something. The name is long. এইটো নহয় কোনো। CW1. Huh. 16, there is no material. Okay, ma'am. Got it. So there is nothing here to, other than the incorporations made by him in the application form, other there is no material. That's it. Okay. Anything more? Yes. Now who will be? We'll hear, madam. Good.
So not really as a defense counsel, but from the papers that I could see and from the reports that was made available, I see that what was the FIR? The allegation in the FIR was that the passport was issued to a person who gave documents of another person. That is the allegation. Now, the person whose documents were used by the allegation is Ramnath, and the person who was given the passport was the Shera. Now, whether Ramnath was brought on dock, they have no explanation, nothing why that person was not
Ramnath is an imaginary figure.
that I thought so. Then a whole night I was thinking about it. When I checked the records, I see that he is not an imaginary figure. He has an account, and it appears from whatever papers that
account in that Bank of India.
Paris. Now that this person.
No, the allegation of the prosecution is that Shera tried to impersonate as Ramnath.
And
for that, he wanted a passport. And accordingly, he made this conspiracy and got this passport in the name of Sarah. In the name of Ramnath. But here Ramnath has got no role, at least to say. You are for S.N. Majumdar.
Yes, in this case, yes.
You have not verified two things. You have not verified the deficiencies in the application form. Two, you have not seen why it was not sent for police report.
Answer to both.
Two. Three, without this, you directed for issuance of the passport. What do you have to say on these 3 points?
I will say on this, but one thing I will also point out one thing, my lord, that ultimately what is the offense? The offense is on the basis of some application, that proper verification. If you go by the allegation, one passport was issued. Now that passport is also not before the court. If we just have the exhibit, my lord, the passport.
Photocopy of the passport is there.
Photocopy, and that photocopy is also actually whether it is a legible copy and whether it is really a copy of that original copy. And I see from the records there was a
this issue was never you had not objected to the admission of that as an exhibit before the tribunal.
Objection.
Huh?
It's under objection.
It's under objection.
Under
Okay.
objection, and it is not really marked as an exhibit. That document is marked as document X, document 10, if I may say so. And document 10, there are two documents, document 10. Now, which document is this? One is, if my lords have the records, it is at page
The exhibit file. Exhibit file, madam.
Exhibit file. At page 51, there is one document marked document X, and there is another same mark at page 134.
$134.
The same marking. And this document is not exhibited.
134 is the question document, that letter from the Superintendent of Police.
Whatever, but the marking is document X, document 10, X, whatever we may say so. And this photocopy also, my lord may see just the kind of photocopy.
No,
Whether
this was not exhibited. There is a reason for that. Because the original was taken away by a man posing himself to be Ramnath. There are materials on record.
but then that person was in the dock. Ultimately, my lord, this is a criminal trial, and beyond all reasonable doubt has to be done. We cannot go by preponderance. So that I'm just pointing out that is a major issue that is a prime consideration before this honorable court as to whether, in the absence of the offense object being not exhibited and not being called for, and there being no explanation, they could have filed an application for secondary evidence, which they did not do.
No. They should have brought this on record. You mean to say that they should have exhibited this? Okay.
That is also one. And then the photocopy that has been produced, that too by a premier agency, and a document which was held by the passport office, and it was around 1995. This photocopy machines had just come in Guwahati, Assam, so far as I know that time. Around 1994, I think photocopy machines started coming. So we really had very new machines, and whether it was new or not new, whether that photocopy, because ultimately the question that is arising is whether that person is the same person or not. And from this photocopy, we cannot identify whether it is the photo of Ramnath or photo of Mr. Shera. And so far as Mr. Shera is concerned, whether his identity was actually the person who appeared, the person whose documents are sought to be exhibited, whether that person was Mr. Shera, we still have a question, because he impersonated. Thereafter, whether the investigating agency took that pain, which they think that that small peon should have taken to find out that there is no impersonation, did they do it? And they were handling what? They were handling a case of impersonation. So someone appeared. We do not know whether that was Mr. Shera. And now they say he's dead, if I heard correct.
No, he is not dead. He is alive. Shera is alive. Dead. Then your case stands abated.
That we do not know.
Item 42.
Because it's a case of impersonation, that statement also how guarded it should be and how guarded we should accept that is also one consideration before the...
This aspect was not considered by the trial court.
It wasn't. And I will just point out one more thing. Things which I need to point out. The application form, which
Exhibit
should be the base. My lord, may kindly see the exhibit 1. Yesterday when I saw, there is one very crucial part of the document. It is cut out. And from the cutout, which I could see from my visible physical eyes, the cutout is not very old. It is not at least of 1990.
What cutout?
At page 5 of that page 5, and my lord may see the reverse page, reverse. There's a box with a signature which has been not there, and whether this happened after after the document was exhibited, or at the time when it was being exhibited, or before it was even seized, there is no such indication at the time of seizure that this document is in such a condition, and therefore a strong inference goes that at the time when the document was in the custody of the investigating agency, this document was mutilated, if I may use that term. And that is done very designedly. Your Honor may see, I know that.
What is done, subject to, we'll have Miss Madam do it. There are two signatures made. One of the signatures is taken out from there and put in the passport proper. I think that's one of the reason.
At the time of seizure.
No. This is a normal thing. T1, please put two specimen signatures or thumb impression in the box given below. Now, what they do is, once this is there, this is taken out from here. Now they can scan it. Earlier there was no scanner. They take it out and I think they put it somewhere.
That may be a presumption, my lord, but to so far as...
No, if that is the procedure, then there will be no issue.
That we do not know back, because that no such case has been put up before this honorable court or the trial court. But the fact remains that at the time when seizure was made, there should have been a mention of this fact. Even if it was so, there should have been a mention, because according to them, they have taken the whole application. And then if I may also go, so far as the FIR is concerned, because there is a allegation of impersonation, in the FIR was registered with section 12(1)(b) of the Indian Passport Act as well. Now, at the time of filing of charge sheet, was it that the investigating authority formed an opinion that there was no impersonation and that is why the passport section offense was removed? That is not answered by the prosecution.
Okay.
So that impersonation goes, if the passport, the offense under the
12(1) of the Passport Act.
12, yes, 12(1)(b) of the Passport Act. Now, if we come to the PC Act provisions 13. If we come to the provisions 13(1). D. Because that is what I was brought under as well. D1 says, by corrupt or illegal means, obtains for himself or for any other person any valuable thing of pecuniary advantage. There was no such thing brought out by in the
no evidence to that effect.
Yes. Then next one also, by abusing his position as a public servant obtains for himself or for any other person any valuable thing or pecuniary advantage, or next, while holding office as public servant, obtains for any person any valuable thing or pecuniary advantage without any public interest, or E is not brought. Now in the this 13(1)(2), any public servant who commits criminal misconduct shall be punishable. Now what is misconduct is in 13. It has to come under the offense of misconduct, then it has to come under 13(1). ABC. And in my respectful submission, if I require, I'll read, but in my respectful submission, none of these ingredients are attracted. He is not habitual, or he does not obtain or agree to accept or attempt to obtain from any person gratification, etc. These things are not brought here.
Gratification is not proved.
Yes. And is not even not proved, is not even alleged. Then B, he habitually accepts or obtains, agrees. This also is not attracted. Then C, if he dishonestly or fraudulently misappropriates or otherwise converts to his own use. This also, so that misconduct does not come. 13(D) goes, and in my respectful submission, 13(1)(D) also goes, as well as 13(2). Now coming to the if I may say, let us assume it to be a fact that the application, that the procedure that ought to have been followed has not been followed. My lord, that will cover, and that is not covered under the PC Act. Then whether it is covered under 420, 120B, 120B, I am keeping it aside for a while. 420 as a PSC left. 471, 468. Now 471, 468, there is no allegation against the passport officers, and therefore 471 and 468 goes. 30 PC Act already went. Now I need to come to 420. Now 420 is what? 420 is that impersonation that has been brought. Cheating by impersonation. Now who impersonated? Not the passport officers or the passport employees, if I may say so. It is Sarah who did impersonated. That is the allegation, and that is what they proved, if they did. So 420 is also I am not covered. Now 120B.
You're making your submissions.
I'm making
Just to add to that. Go through this on your own. Just go through that. This is the starting point which led to the whole.
Yes, this I have. I will place it also. This I will.
You have gone through that.
I have gone through that.
Because that seems to be the basis for the whole building that was built.
Correct. And that's that is in fact an important witness. Now, so far as 120B is concerned, that they have to show with evidence that there was
Meeting of mind.
meeting of mind.
That was what I was asking, madam, that where is the meeting of mind of A4 with the other two? When I'm considering that, there is nothing on record.
There isn't. Actually, since I was going through the records as an amicus, I don't find anything that 120B really comes in. Now, my lord, at the most, that too not undoubtedly, I will say, at the most that this one, PW1 has talked about Anjali Thakuria. As she's a daily rate worker. At the most, maybe somewhere, maybe she must have been taken into confidence.
No, but she says that, see, the normal thing is we'll hold her that she's been assigned that work. We are not concerned whether she's a casual Muslim. Her duty is that once this application forms come and it is put up by the clerk or by the dealing assistant, she has to fill up a personal information form.
Yes, personal information.
Whether it is of, because at that point of time, 7 states was being serviced from here.
Exactly.
So if it is of Guwahati, then there is a Assam police register. She will enter it there, and from there it will go to the concerned IGP, from IGP to the concerned SP. Here, she had put up that. But Rupak Gogoi had not sent it. He kept the file. And thereafter, when the time 28-30 days was over, he put up that no report is there. So the passport can be issued, and SN Majumdar directed in that form, that last page 6, directed issue. So here Rupak's role is a bit
Yes.
is a bit doubtful.
Yes.
We'll have to have some clarity there. But I'm still to find something with regard to TT, when that person who accepted he did something. But how he is got connected with the whole thing?
There isn't. There isn't.
And you have thrown light with regard to 120B. Okay, fine. Then next.
Then now, if PW1, since this honorable court has already gone into the evidence, I believe.
No, we'll meticulously go through that once more. There is no issue.
W1.
No. It's okay. You need not take the trouble.
Because here he has mentioned the kind of the way the procedure.
How it is to be done.
So PW1 is that way important. Then PW3, PW4, PW7.
It's fine. Madam, I got your points. Can you give me a small note? Trouble you.
Yes. No, I just made one for myself, a little bit of elaboration.
And some judgments if you can.
Yes.
Madam, you have got
I found out some judgments.
got the points now. I think you got to go a bit more deeper. Because your procedurally, it seems that PW9 statement that there was a direction and the whole thing was done. So you got to dispel that. You get my point? You got to dispel that. I'm not rushing you up. Prepare a bit more. PC Act plus... No, madam. With Rupak Gogoi, we find something. But Rupak Gogoi and Chera, let's say that it's not a case, but Chera and Rupak Gogoi, there is something because the matter was not sent to the police. If it was sent to the police, everything would have come out. To that extent. But TT, he receives. After that, there is no allegation against him. SN Majumdar, maybe it was put up before him with the thing that, okay, 28 days is over. Police report has not come. So there was a procedure, it can be given. So he directed for giving. So it's very difficult. There is no connection between the works done by SN and Tirmal. And the link seems to be Rupak. So you got to establish a link from Tirmal to Rupak, Rupak to SN Majumdar and back. So that the complete transaction is clear. Unfortunately, I'm not... Madam, I'm not very... I've been reading, I've not been very sanguine. And I'm thankful to Madam that she has brought it out in a lucid manner. Madam, you should establish that, see, this you have done it because you wanted to help him. Connect it up. Your investigating officers have not gone to that extent, unfortunately. But if they have gone, I might have missed out. Kindly show me. When? Tuesday?
19th.
19th. 19th. Okay, when can you do it? Before that? 19. Yes, next.
I'm, okay.
I'll pass the orders. Take it off to my toes. You are for Mr. Sharma, you are for huh?
But Mr. Sarah, I for Sarah.
42. You are for 42 also.
Yes, expired.
42 likha so.
Also, one he has already stated, and even my,
In futility then. Okay. Madam, you just have an instant. Please do that. Ma'am, you are the standing retaining counsel. Tell them get this instruction. Orders are not required for everything. Likha. Item number 42. Mr. S. Sharma, S. J. Sharma, learned counsel appearing for the appellant, submits that during the pendency of the present proceeding, you have a date had passed on, comma, on
24th August 22.
24/8/2022. Also, the said position is not disputed by the learned standing counsel, CBI. Learned standing counsel, SBI, CBI, submits that she has got no instructions in this connection. Full stop. The said submission having been made by the learned counsel for the petitioner on instructions, comma, this court accepts the same. Also, accordingly, the appeal stands abated. Item number 43, 44, 45. 43, 44, 45. The learned counsels of the parties have made their respective submission. However, the hearing remains inconclusive. A registry to list this matter again on 19/9/2025. 19 we'll finish up with, madam. We'll take your matter on 18th if required.
18th, yes.
18 koi 18 any problem? 19 you come on 19. 18 koi 43 or 44 19 koi dia.
18.
Delete koi 18 koi 18 koi 18.
Watching suppose क्या case में
You have an interim order on your favor. Respondent number 2's copies of nobody has appeared. Yes, state is there. It's a private claim. We'll hear it. Raised, heard the learned counsel for the parties, comma, as agreed to the, as prayed for by the learned counsel for the parties, registry to list this matter in the last week of October 2025 on a date to be fixed by for admissions. Anything very urgent? Anything very urgent? Oh, we had a full cup today. Yes.
30, my lord. 30,
You're in this matter. 16. 16 and
34, my lord.
uh,
They have come up together, my lord. 34, we have.
as prayed for by the Learned Council for the parties registered to list this matter again in the last week of October 2025, along with item number,
34, my lord. Lordship's list, my lord.
along with criminal petition number 1375/2019. Huh? Okay. A Kali 1375/2019, item number 34, it would matter to come up along with Eketa order, ulta to koriba. Done.
But in this,
Item number 16 on interim order as continue border cases.
no, my lord. 34, there is no interim order, my lord. No, there is no interim order.
Yes.
34 to some.
There is no interim order, my lord.
Yes, there is an interim order. Call for the scan copy of the case diaries for both the cases aforementioned. Now, where is the interim order? Any IA? IA to the assume.
Aye, my lord.
Oh.
Beg my lord's pardon, my lord.
Mr. Mohan.
I beg my lord's pardon, my lord.
Huh? Where is the interim order? Invisible interim orders are not normally passed by this court. Huh? Verbal interim order. Huh? There are interim orders, but those are not. Those are to the effect calling the case diary. If those are interlocutory orders. There is no interim order.
Criminal petition 851. Is it?
Here there is a clear that connection with Bhangagar PS case number 243/2019 is stayed, right? But in your case, there is a cross case.
Yes, cross case.
Okay. 851 interim order to continue till the next day promised.
Pleasure. Hi,
Please, the other day when I put this application, it's pending, that's it. Several petition so any instruct pending or not pending, lordship may pass any order, lordship. They have approached there. They
No, have you paid? You will know how much you have paid.
as far as my instruction lordship, there is no pending dues.
From 2014, you have cleared all the dues.
Lordship has been no pending, lordship.
No pending means have you cleared from 2014?
Lordship, my case is that from time to time.
It's not your Miadi land. It's not your Miadi land. It's government land, public land. So you have been occupying on the basis of some offer made by some officer.
Case is that I have been verbally allotted. That is
verbally allotted. Is it the person who allotted, is it his Miadi Patta?
That case is different case, lordship. Julius item 70.
This court wants it. This court wants it.
Case regarding lordship, some two states, lordship.
You have not brought it on. You are not disclosing whether from 2014, that is the only thing we wanted. Whether you have been paying your rent from 2014. You say you have not been paying, we will take over. We will pass orders. Nothing. Appropriate orders we will pass. Order is very clear.
Yes, Lord, that is right, lordship, because land has not been assessed. Because we have filed several representations to assess the land, lordship. We are given.
Hey, the government to kill Kumbaya N. Goswami ba.
Is that, lordship, during stay.
Mr. Kulta, I'm not interested whether what is happening. I'm saying whether from 2014 you have paid your rent. 1 rupee, then 1 rupee. Have you paid? That's the only question. Yes or no?
By instruction, Lordship, he has not paid because.
He has not paid.
Rent has not been assessed, Lordship.
Okay.
If it is assessed, Lordship.
Mr. D. Kolita, learned counsel for the petitioner on instruction. D. Kolita, learned counsel for the petitioner in terms of the queries raised by this court wide order dated 3/9/2025 has on instruction submitted that the petitioner has not paid any rent for the shed occupied by him for the commercial shed number 13 occupied by him at the commercial estate Margarita. He further submits that the said amount has not been paid on account of the fact that there was no assessment made of the rent amount due to be paid by the petitioner herein. First up, in view of the above position, the petitioner is directed to appear before the, who will do this?
Petitioner Julius Setias also.
No, who will do this? The commercial, before the general manager,
Lordship.
District Industries and Commerce Center, Tinsukia, on or before 17/9/2025, along with an application requesting the said authority for assessing the rent due from him for the occupation of the said shed from 2014. So, on receipt of such along with a certified copy of this order, on receipt of the said application, the General Manager, District Industries and Commerce Center, Tinsukia, shall ascertain the amount due from the petitioner and inform the same to him in writing. The petitioner shall thereafter clear the rent as due from him. Also, the learned counsel for the petitioner shall apprise this court on the next date of listing the developments taking place in the matter. Also, the learned government advocate is directed to forward a copy of this, a downloaded copy of this order to the Commissioner and Secretary to the Commissioner, Industries and Commerce, Respondent number 3, as well as the General Manager, District Industries and Commerce Center, Tinsukia, Respondent number 4 hearing. Also, in the event the petitioner fails to approach the Respondent number 4 in terms of the directions passed herein above, appropriate orders as would be mandated in the matter would be passed on the next date of listing. Registry to list this matter again on 15/10/2025 for further hearing. These things are not acceptable. There are many people who will want to use that thing. Yes, respondent. None appears for the petitioner on call. Mr. N. Amit, learned counsel for the respondent number or sole respondent is present. For the ends of justice, registry to list this matter again in the month of October 2025 after the ensuing vacations, puja vacations.
Action from my client, he is willing to pay, but Lordship subject to the receipt of the detailed bills. Because in first order, Lordship will find that on 23/5/2023, up to
no details bill, whatever they have given you, you do it, then you come.
No, I'm not agreeing to it. Because 2023, Lordship, on 17, in the year 2017, the amount was 17 lakhs. Almost it is 18 lakhs. All of a sudden, in the year 2020, the lease is terminated by then.
So you are agreeable to pay 20 lakhs?
No, I am not on that.
What are you agreeing?
First, I want
bill, Lordship. Thereafter, Lordship, the extent which I can.
Mr. MM Zaman, Learned Counsel for the respondents. Respondent number 3 has placed on record the calculation made with regard to the arrears of rent receivable from the petitioner. It is the grievance of the petitioner that the rent has not been paid by him because the breakup of the same month-wise was not provided to him. First up, Mr. Zaman shall furnish to Mr. Dutta a copy of the instructions received by him along with the calculation sheet annexed thereto. Mr. Pathak, now having received the said, Mr. Dutta shall forward the same to the Learned Counsel for the forward the same to the petitioner, who shall forthwith proceed to clear the said amount. In the event there is any dispute with regard to the calculations so set out in the said communication, comma, the same would the petitioner, after making the payments involved, would be entitled to submit appropriate applications for recovery, for disputing the same and for recovery of the amount so paid. A copy of the communication dated 8/2/2023 is kept on record and marked as X. Or you want to take instructions?
Take instruction because.
Furnish the same to Mr. Dotto. But this is the order that will come. Mr. Dotto shall receive his instructions in the matter and apprise this court on 15/9/2025. Registered to list this matter on 15/9/2025 for further hearing.
May I please?
Hmm.
This transfer petition has been filed for transferring a DB case which is pending with petition with Magistrate First Class Kamrup Metro. Any other?
What is your instruction with regard to transportation expenses?
Lordship, we could say.
Bedridden. What happened?
Bedridden because actually he has lots. He has got lots of problems. Spinal problem. He is not.
Where is your medical certificate to that extent?
Lordship, since 2014, he has got some.
Where is that medical certificate?
Lordship, at page 19, page 19 to
19.
19 to till the page.
Oh,
So many. Because since 2014.
mine 4, 5, 7 all gone.
If even
You're also go and check up. You will also have. This is modern lifestyle.
till now he is undergoing treatment. Even the hearing loss also.
They're under stay. The proceedings are under stay.
Yes, Lordship.
Mild hearing loss. Oh.
Because Lordship.
I know that. I've seen it. Madam, this is not a ground.
Even neuro problem also, he is undergoing treatment.
Neural, every fourth person will have the same very problems. But the world is going on.
Above all, Lordship, he has some hearing loss. Huh?
Oh, hearing loss is not nothing will prevent him from walking.
Prior to the Lordship, prior to the marriage also, no, he has
Cardio, diabetes. These are all common things.
And recently he fell down in his home.
But that fell down, he might be thinking something else and he fell down.
And then he got hurt. That's why I could not contact him. We tried our best to contact him.
You want me to bring him here to see how he is? Then if he can come here, why can't he go there?
If he can, with the wheelchair, he'll be available. Wheelchair, he'll come.
Oh. I'm not satisfied. Aju, Kamrup, nearby. And where is his house?
Kamrup Metro. Nunmati.
Nunmati. Tampur.
No, she's staying.
Nowadays, the road connection is very good.
No, and he is in
Nunmati.
Anand.
And he was to go till Dampur.
Actually, the 2 cases are Lordship, 2 cases are pending in the Kamrup.
Earlier, the roads condition was very bad. Now it's very good. I've been there recently.
Lordship, lots of speed breakers are there. If he moves also, no, like,
That you file, ask him to file a PIF. That there are too much of road breakers in there. That is not a ground. We are not satisfied.
because she has filed 2 cases in the Kamrup Metroship. Well, she herself is coming. She herself, I have not filed. She has no complaint regarding coming to the Kamrup Metro.
A lady, she is having any source of income. Then?
And she herself filed, Lordship.
Hmm?
No interim has been given in
Here,
the TV case.
TV case also.
But maintenance case is pending before the Kamrup Metro, and then some order has been passed. That is.
You have got a maintenance 125 in the,
Yes, sir.
no order has been passed.
No, it's passed. That
Interim
is-
order,
Yeah, yes, Lordship.
how much rupees
4,000.
per month?
This is the order.
And if she gets 4,000, any children?
No.
No
Only
children.
2 days she got married on 1/10/2023, and she left home on 22/12.
Okay.
2000. Only 2.
Ms. Paul, learned counsel for the petitioner submits that she has not been, she be granted a further 2 weeks time to complete her instructions in the matter. So, the petitioner is granted, learned counsel for the petitioner as a last chance is granted 2 weeks further time. So, registry to list this matter again after 2 weeks. No further adjournment shall be granted in the matter. We'll finish it off next day. Man, I'm not.
Maintenance there already been granted.
4,000, and with that 4,000, she'll
This is
try,
just the
she'll
interest.
commute to Guwahati. You give her, that's why we said,
But she could
give her full expenses.
She
Car
kind of-
expenses from there to here, we will see them. Expenses, that's all.
But I'm
She'll come.
unemployed. I'm not. No, prior to
Your
the-
hands are working. See the
Right.
Supreme Court judgments.
Prior to the marriage,
Madam?
then knowledge.
You fix the quantum of compensation of the expenses that she will have to bear, get that instruction, we'll have it transferred, no problem. Otherwise, you will have to go there.
Obliged, Lordship. You know? Right.
Dear Lordship may fix thing, Lordship.
The registry to list this, it is submitted that the paper book in the matter is prepared. Accordingly, registry to list this matter for hearing on 22/9/2025. 22/9. Pune Mati Odisha. What is the interim order?
State.
2 সপ্তাহ দিছিলো না? হা?
Till then,
2 সপ্তাহ দিছিলো না? এটো ফিক্স করা 18/9 or 18/9 till 18/9. 18/9. Interim order to continue till the next day. 18/9, ma'am, get your instructions.
Receive, Lordship. And
Even 24. The trial court records have been received. Also. Anybody appearing for the respondent? Yes, Mr. Counsel.
Their name not.
1 to 4.
Their name is reflected, Lordship. G. Rahman S. Ahmed.
Where?
The cause list, Lordship.
Item number?
24, Lordship. Cause list, Lordship.
The trial court records have been received. Okay. The matter is otherwise ready for hearing. Accordingly, admit the appeal. The registry to list this matter, list the appeal for hearing in the month of November on a date to be fixed by it.
If you have like.
So we were directed to take fresh steps. We have taken steps on several occasions. On the last known address of the addressee. Lordship, the letter as per the office note dated 26/8/2025, the letter had returned saying that addressee not found. However, Lordship, they had filed a criminal leave petition where the particular address that they had provided, we took step in that address as well.
Criminal
Criminal petition. They had filed a criminal petition, the respondent.
for this court.
Before this court. Had issued notice in this particular address. That they were the petitioners.
Is it got anything to do with you? Yes. You are the respondent here.
Yes, we were the respondents.
Okay.
Here.
There is a way out. This is criminal petition. The learned counsel for the petitioner submits that. Your name?
P. Gupta.
Ms. P. Gupta, learned counsel for the petitioner, submits that the steps have been taken, fresh steps were taken upon for service of notice upon the respondent number
2 and 3.
2 and 3 at the address which was disclosed by them in the proceedings of criminal revision petition 160/2019 instituted by the respondent number 2 and 3 as petitioners. However, they said notice however, the office note dated 26/8/2025 reveals that the notice issued upon respondent number 2 has been received back with the remark addressee left. Also, accordingly, she prays that the present petition be taken up along with criminal revision petition number.
Lordship, that has already been
Disposed of.
the final order. My humble prayer is to proceed this matter ex parte.
Cannot be.
Or else paper publication. We had asked the counsel for the opposite side to give us the new address. They refused to furnish the new address as well.
In view of the above, petitioner is permitted to take usual process also not done.
Usual process, postal talabana done, AD card done. We have taken steps 3-4 times.
Permitted to take steps upon the respondent number 2 and 3 by way of substituted service by publication of the notice in 2 daily newspapers circulating within the 2 daily newspapers. Full stop. The said publication be made the publication be made by routing the same through the registry of this court. Full stop. The petitioner to publish the notice in the daily Assam Tribune and then the second one.
Regional language newspaper.
Which one? You can do it in Doinik Ahom and a vernacular daily, and in the vernacular daily, Doinik Ahom. Upon publishing of the said notice in the newspaper, petitioner to file an affidavit to that effect for this court. Registry to list this matter again on 24/10/2025. steps for publication be taken within a period of 1 week from today.
May I please, Lordship? Here as per office only 29, my lord. It's not a necessary party. The appeal is ready for hearing. My lord.
Informant is not, this is not a case wherein that POSCO or 376 is involved.
376, my lord. So otherwise the case is ready for hearing. My lord. Where is there, my lord?
Private respondent, informant is not required here. Considering the nature of the offense involved in the present proceedings, this court is of the considered view that the presence of the respondent number 2 informant would not be mandated, would not be required. Accordingly, the trial court records having been received, registry to list this matter for hearing when?
Hearing on 8/4/16.
Hmm?
Wait for hearing on 8/4/2016. My lord.
It was already listed.
Admitted for hearing, my lord. On
Oh, admitted. Oh, it is already admitted. Not like admitted. Yes.
8/4/2016, first order, my lord.
Oh, as the trial court records, as the trial court records have been received, registry to list this matter for hearing on when?
19th, my lord.
On 14/10/2025.
Right.
Yeah, please, Your Honor. Have been received, my lord. Hearing, my lord. Not dated, my lord, 5/9/2025.
You are for respond number? How come there is 4 here? No, there is no respondent number 4. Is there a respondent number 4 here? Item number?
Item number 28.
192/2016.
Yes.
Then last order, there is a reference for respond number 4. That's why I asked. So LCR pala ahil ne? LCR ahil.
LCR has been received, my lord.
The respondents are represented. The trial court records have also been received. Accordingly, registry to list this matter for not admitted.
Yes, my lord.
Admitted.
Admitted, my lord.
For hearing in the month of November 2025.
Most obliged, Your Honor.
None appears for the parties on call. Registry to list for the ends of justice. Registry to list this matter again after 2 weeks. Uh, 2 weeks. List this matter again on 23/9/2025.
Interim order shall be called.
You are here. Oh, Mr. What happened to the payment?
Item 30.
I'm on 29. 30. I'm sorry, I'm 29. Service complete.
My lord, notice has been issued, my lord. Last order, my lord. 9/5/2020. 27/8/2025.
Oh. Registry to place the matter before the Laojima court with regard to examining the completion of certificate service upon the respondent number 2.
There's an interim order.
Interim order passed earlier to continue till the next date. 23, the notice was given. In 25, you want to. Okay, fine. Mr. Chaudhary will take care.
My lord, in this case, my lord, what happened, my lord? There is an order passed by this honorable court that section 5, section 6 notice is not available. Interesting case. Thereafter, court said you verify there is any section. The court has opined that section 5, section 6 notice. Section 5, section you know very well. Delhi police establishment. For the investigation, that consent is necessary. There are, my lord, for one FIR, they have given two, my lord, charge sheet has been filed, two separate cases. For this second case, I am there, where sanction is not, consent is not there, my lord.
Consent not given.
Not there, my lord. And my lord, so there second time, the court has said it cannot proceed the matter. But charge has been framed earlier, my lord. So he said matter will be fixed for everything. And stay order has been passed. You cannot proceed that trial.
Okay, next time. I'll also learn next time. Yeah.
Your Lordship, as per the office note dated 24/9/2020, as regards to service, I may come up for assistance.
There is a simple matter.
You are for? Who is for 1, 2? In this proceeding. Where? Are you 103? Where is that order? Order of? Order dated? In some IA or in this one only? It is listed, both are listed today. Oh, it is passed in that order. It's not been brought here. Now, what is the similar matter pending? What is that number? Criminal Rev P28. It is submitted that a analogous matter is pending disposal with before this court. Analogous matter being criminal revision petition 328/18 is pending disposal of before this court, and accordingly the parties pray that the present criminal revision petition be directed to be listed along with criminal revision petition number 328/2018 after 2 weeks on a date to be fixed by the registry. Let it come, we'll see. Because that order, if you have that, it's not here. It is in that case, maybe. So if it comes, we will do this. And if it is respond number 2 is not there, take steps. Have you understood what is happening? Huh? কোনোবা ফাইলৰ লগত বাধা আছিল ন এইটো পোৱা নাছিলো এইটো It is seen that a full stop. None has appeared for the petitioner on call. It is seen that even on the last date of listing, the petitioner had not appeared. Full stop. Can we get the petitioner here? Because there was a direction for payment of enhanced amount. He has not done that in all probability. Can we direct the local police station to serve a notice upon him so that he can appear? The registry to issue notice upon the petitioner through the jurisdictional police station requiring his presence before this court on 24/9/2025 at 10:30 a.m. Right? That'll do. Because that money is there. This court had directed. After that, nobody, even the advocate, is not appearing now. We'll get the petitioner. Huh? Dekisa? Kiman tarikh? 24. Eto immediate ajay of janai diba.
For the petition is not complete. Steps was taken long back 24/2023.
In the office note dated 28/7/2025, which indicates that the service upon respond number 1 has been effected through the usual process. The report of the Chief Judicial Magistrate Sipsagar about effecting of such a certificate is also available on record. In view of the above, the service being complete, a registry to list this matter for admission after 3 weeks on a date to be fixed by it.
We have not received any.
Huh?
The steps. For instruction.
You have not given steps, not taken steps.
We have taken.
In 2025, we were directed.
The learned counsel for the appellant has submitted that he has already taken up the matter with the appellant to receive the present address of the respondent number of the sole respondent. Accordingly, he submits that he be granted 2 weeks' time to receive the present address of the petitioner and for taking steps upon the said respondent, taking fresh steps upon the said respondent as directed by this court, wide order dated 11/8/2025. Yes, what is this?
May I please, my lord? My lord, item number 37, my lord. It's the division bench matter, my lord. Secretarial appeal jail, my lord.
Punishment?
Division. Punishment 20 years, my lord.
And in this one?
How? Take.
Same case.
No, my lord. Only my 37 item. Not other matter.
Other matter is not connected with
Yes.
the criminal appeal. Yours is? Okay. Digonto Das.
Yes, they can do this.
It has got no connection with the other
Yes.
cases.
Correct.
No connection.
No connection.
Separate offense,
Separate,
separate case.
separate.
Okay.
Division.
Item number 37 Likha. Mr. A.
Hey,
Dr.
Dr. Mali.
Learned counsel for the petitioner submits that the said matter has been wrongly tagged along with the criminal appeal number 285/2022 and criminal appeal 6 of 2023. Right?
Yes, my lord. Correct.
No. Wrongly tagged with criminal appeal number 285/2022. Also, he submits that the criminal appeal number 26/2023 would be required to be considered by a division bench of this court. Also, in view of the above submission, what are these IAs for?
Bail, my lord.
Bail. In view of the above, criminal appeal number 6/2023 be detached from criminal appeal number 285/2022 and be listed before the appropriate bench. Also, item number 36. Who is appearing for item number 36? 285? Your name, nobody is there.
No.
None appears for the petitioner, huh? 38 is again criminal appeal 6. Oh no. 6 of 23. Oh, that is different. Bikram Theron is also different, Mr. File kita song. Oh, that is different, na? Son. To postpone. Jail. This is same. 6 of 2019. Okay. Jail appeal and this is same. Okay. Hey, kata sun, kata. Tumi likha. Item number 37, huh? Tintai likhit hoba, huh? Mr. A. Dr. Learned counsel for the petitioner submits that the said matter has been wrongly tagged along with criminal appeal number 285/2022 and criminal appeal bracketed jail number 6/2023. He submits that the present appeal would be required to be considered by the division bench of this court. So accordingly, registry to detag criminal appeal number 2023 along with the connected interlocutory applications and place before the appropriate bench. All?
Yes.
Also, A2 likha, criminal appeal number 285/2022, Aru criminal appeal bracketed jail 6/2023. None appears for deputy appellants on call. However, Mr. MP Goswami, learned additional public prosecutor, is present. For the ends of justice, the registry to list this matter again after 3 weeks on a date to fix.
My matter.
Okay. We'll see. Let it come.
Yes, may I please, my lord, next week maybe if
I can't. That you go. That this will go and do it. That division bench we can't direct. Some propriety we have to maintain. How can I direct the division bench to place before the next week?
Not 3 weeks.
Division bench
May I
can
request,
direct.
my lord, 2 weeks maybe time maybe. 2 weeks.
2 weeks. Okay, 2 weeks.
Deeply obliged, my lord.
I can give you 1 week also. 1 week query.
Oh.
Yeah.
Deeply obliged, my lord.
Where the appellant was convicted under section 6 for 10 years, Lordship. He is in custody for about 3 years, 9 months. Okay, Lordship. From the record, Lordship, what it appears to me, Lordship, subject to what my learned friend say, a case of attempt, Lordship. That case, Lordship, section 9M will be attracted, punishable with 5 years to 7 years, Lordship.
Just a second. Where is the judgment?
Judgment, your Lordship will find.
Girl is around 7 to 9 years. Where is the judgment?
Our judgment is page 30, start from page 31.
It give an A. 31 or so.
There, no. Was examined as PW.
Just a moment. I did not go through it. That's why. So it is only PW2, the victim girl, and the others are reported. What is the medical evidence?
No sign of.
No, medical evidence is injury on the inner side of both thighs.
That allegation is not made.
Fine. 8-9 years girl, but she was the one who has been examined.
Lordship, she got injury in her lip.
So this is the 2 points.
Second, Lordship, from her evidence, your Lordship will see that only attempt is there.
9-year-old girl.
That I am not disputing. But from the facts, Lordship, may kindly see PW.
Okay, where is the evidence of the doctor?
Doctor's evidence is at page 19. W8.
Nothing cross.
That not there.
Your cross, you have not demolished it. Huh?
That I have seen.
Then how can we ignore that medical opinion?
The medical opinion, Lordship, I am not disputing because if your Lordship see that C, column number C, simple nature, and number B, she might not have been exposed. That part I am
fine. It's not required. Your attempt is enough.
For attempt, Lordship, I am not praying for clean acquittal here.